Served on the commission as a representative from the legislature, and we're most pleased you're taking your time and your work that went into that too over the last year. I don't know if we have any other legislators present. I invited others to attend if they wish to come and hear this, because this is a matter of vital concern, I think, to the citizens of Georgia, all our constituents. We have Joy Hawkins in the back. Joy, if you would please let us know that you're present. She also served as an appointee to the commission, and we're also very grateful for her work. She was working with the governor's staff and now has moved on to somewhat the private sector. So pleased to have you with us. And with that, Judge Abbott, I'm going to turn it over to you and let you just take it as you wish and go with it all directions.
Thank you very much, Chairman Willard, and thank you all for having me here today. I'm glad to have the opportunity to meet with you again. Also just exciting to be up here at the Capitol when it's full of people. I've spent a lot of time here over the past 9 months when it was just Diane and me a lot of times, it seemed like. So it's been quite exciting to be here today. I also want to acknowledge Judge Michael Key, who is here. Judge Key is a juvenile court judge, and he serves as a commission member and served on the Statute Review Committee as well, and I appreciate his being here.
My apologies, Judge Key.
I appreciate your outlining for me what the anticipation is for what I will do here today. I will be speaking to you as a commission member. I am also a Superior Court judge, and so certainly I can put on my judge hat if there is some question that may be addressed to sort of the judicial aspects of this. But I appear to report to you and to answer questions for you about what the Commission has recommended. I do think that it is important to recall and to acknowledge that at this point, House Bill 221 is slated to go into effect on July 1, 2006. And House Bill 221, of course, amended, repealed, and created a number of provisions. I also think it's important to point out that the Commission was specifically charged with two really vital roles. We have many duties because this is an ongoing permanent commission, unlike the every 4-year blue ribbon commissions that previously existed. That the two vital roles were to recommend the adoption of the tables, which are an integral part of an income shares guideline system. And so a great deal of time was spent on that, and we were very fortunate in connection with the tables to have the assistance of economist Dr. Roger Tutterow, who was the chair of the committee that handled that, and I will go into more detail about that in just a moment. I want to thank a number of people as well who are here today, because without them, really, we would not have been able to accomplish anything. Our staff attorney, Jill Radwin, is here. Jill has been remarkable. Legislative counsel Jill Travis worked with us hand in hand, was at every statute review meeting and every commission meeting, and of course was able to turn our recommendations into something that looked familiar to you all, which was helpful. Representative Earhart's then intern, Sarah Larios, was vital. Council of Superior Court Judges, Mike Cuccaro was enormously helpful. We had a great deal of input from a diverse group of people. The family law section, a number of whom are here today, Steve Steele, Sandy Bear, I'm not sure who else might be here. The Office of Child Support Enforcement has been enormously supportive and helpful, and I will describe in more detail some of their role as I go through. A number of citizens who were very helpful: Georgia Legal Services, the Office of Dispute Resolution, Commission on Family Violence folks. I mean, we really had a hard-working group, not just of the Commission, but of many people who sacrificed a great deal of their time to bring to this as much breadth and depth as we possibly could. Now, I've told you 221 is slated to go into effect. You all know that. It passed last year. Senate Bill 382 is really a cleanup of 221. I certainly was here involved and know what happened in getting 221 passed, and I think everyone contemplated when 221 passed that it would go through some, I've been calling it primping up. it was a little messy. It had gone through sort of various permutations, and time was running short. And I think everyone realized that 221 needed to receive some close scrutiny to ensure that it was a workable bill with a little bit more elegance about it. And that is essentially what Senate Bill 382 is. And what we did is we sat down with 221 and we went word by word. And we literally went over it dozens of times, having it reviewed over and over and over again. Is there a conflict with another state law? Is there a conflict with federal law? Does this law need to provide more guidance to the users as far as discretion is concerned? Is the law internally consistent? Is it consistent with Georgia case law? Does it read well? Can the user read and understand it so that when you read it, you know how to calculate child support? I mean, we looked at it from all those standpoints. So 221 is in 382 for the most part and for all intents and purposes. It just doesn't look exactly like it looked the last time you all looked at 221. I want to go over a number of things, and just to give you an outline of what I plan to go over, I want to talk about the economic tables, which are before you as a part of Senate Bill 382, and they may have also been introduced by resolution. I'm not certain about that, but that was contemplated. I want to talk about, go through with you some of the most important aspects of 382. I want to talk about the parenting time adjustment, and obviously I'd be happy to answer questions, and that would be very helpful to me to know what matters you all are particularly interested in or have questions about. Let me briefly just address the tables at the outset. As I said, the economic tables are an integral part of an income shares bill. They contain the basic child support obligation, and those tables are not something that the Commission, we do not have the expertise to create that. That is something that is done by, well, actually very few companies and consultants actually create these kinds of tables, and we retain the services of Policy Studies, Inc., which is probably the most well-known. It's a Colorado-based company, and they assigned to the Commission Dr. Jane Venara, who also is a nationally known expert economist on many matters concerning child support, and in particular the tables. She then took 221 and all of the instructions in 221 about the assumptions that needed to be made, such as that it's supposed to be based on Georgia's tax rates and ensure that it was essentially a net income kind of analysis for the tables, any other assumptions that were given direction in the table. In addition, the Economic Study Committee looked at the 5 or 6 studies that have been done since the 80s about how to create such a table. And if you think of the idea of, well, what does it cost for me to raise my child? And that's essentially the question that is asked. How much money do people at certain levels of income need to apply to ensure that their children receive basic kinds of things, the things that we all have to have: food, rent if there's a rental, clothing, transportation, those kinds of things. And they look at these studies, and some of the studies tend to trend high on the numbers, and people consider them to be somewhat biased. In economist terms, it just essentially means that it trends high at certain points because of the way they did the study, and some of these studies trend low or have a lower bias. So the Economic Study Committee asked, show us what the average would look like of these high and low studies. And I'm not going to bore you with all the details about that, and I really couldn't because I'm not an economist myself. But when the tables came back, we looked at them. The average study appeared to be the one that was most in line with the expectations of the Commission, and most consistent at some levels with current awards and those kinds of things. Ultimately, the Commission agreed to recommend to you that you adopt that average table. They are based on the most current economic data. The numbers come out higher than any of our surrounding states in terms of the basic child support obligation, and that is in large part because we have 2005 data, and some states haven't updated their data in many years. And some states try to do this regularly, but it oftentimes becomes a highly political kind of issue, and so they haven't done it. So that is what I have to tell you about the tables, and maybe this would be a good point for me to stop and ask if there are any questions about the economic tables, because I probably won't go back to that. Yes, ma'am.
Right.
When you say that the economic studies analyzed basic needs, don't you think parents provide more than basic needs for their children?
Absolutely, and that's why the statute provides for all of those to be added on.
Do you have an opinion about whether or not this table that averages has the effect of raising or lowering child support for different income groups?
Probably the only area that I can actually say it looks like it will is for the lower income. The table appears to be higher at the low incomes. It's compared to presumptive awards. And I mean, obviously every case is different, so it's virtually impossible to predict how it would compare in any given case, because you've got to factor in all the deviations. And so, as we've said, and as Dr. Venor has explained to us, you're really comparing apples to oranges whenever you try to apply flat percentage presumptive awards to an income shares economic table. They simply aren't the same thing. So it's very hard to say, but at the lower incomes they did go up, and that's why in Senate Bill 382 we recommended that you consider a self-support reserve at that level for both custodial and non-custodial parents in order to ensure subsistence levels for parents.
Want to continue?
Yes, sir.
All right.
I'm aware of how much work y'all have put in, particularly the staff folks over the summer, and it's been a lot of effort, but it's as what I've been told and what it looks to me like on the surface is that the lowest income folks, that it hasn't lowered their child support, but particularly for middle income folks, where most people are, where you have a low income custodial parent and a higher income non-custodial parent, that it does lower child support. And that is what concerns me, and I'd really like to know if that's
there's no way I can generalize about that, though. If you take actual case studies and you actually look at whether or not the court deviated under the flat percentage, and you look at all of that, and then you redo the analysis, in some cases it goes up, in some cases it goes down. It is highly individualized, and because income shares, which is the guideline that is contained in 221, obviously, is very fact intensive, more so than the flat percentage of income, which, as you know, is really a lot of times a sort of a no-brainer. What's the gross income? What's the percentage? And that would you'd arrive at a presumptive award. And unless there were going to be a lot of deviations, there weren't a whole lot of facts brought forward about how much money parties were spending on health insurance for children, daycare, special expenses, extraordinary expenses. The current law simply wasn't that specific. It was broad and flexible, and so it's difficult to generalize, and I can't answer that question in a generalized fashion.
Looking at it in terms of the cases where the figures I know, it lowers child support. In relation to the implementation of this table, in a county where 50% of the people are pro se, would you give me an update, please, about how this is going to work on a practical basis?
Pro se?
Pro se for 50% or
May
pro
I
se?
hold that question
Yes,
for a
sir.
little later point. Senator Harp, did you want to have something you wanted to add to what Judge Abbott has
Yes, sir.
answered?
Sorry, Judge Abbott. Let me add 2 cents on the thing. First of all, I'd like to talk about the economic process and how we did that. I think this is very significant. The commission didn't just come up with the idea that we were going to average. What we did is, in my role as chairman of higher education, directed the Board of Regents, and the Board of Regents was tremendously cooperative, and we had 10 economists from across the state at colleges and universities of the state, and they did independent studies of what it costs to rear a child. And they took the various studies that were done, and what they did is, based upon that, then our primary economist, Dr. Tutterow, then correlated that, and the recommendation of the economist was that we go to this mid-level table of the cost of for the cost of what it takes to provide for a child. And as Judge Abbott has so correctly stated, remember this: the obligation is the very first step in the process. The obligation that the tables give you is only a reflection of the gross income of the two parties, and then you go to the tables and you come back with that. In further response to your question, the middle income individuals are largely unchanged. The lower income individuals are increased. Only as the income tax takes a greater bite out of the income, because remember, these tables take into consideration the fact that we have a graduated income, then and only then do you see a dropping out, and it's above a family income of over $60,000 that you start dropping below the suggested amount of the tables. And as you're very well aware, the present law has, I won't call it a cap, but we have the opt-out at $75,000. So actually what happens is there a very small number of people, and when we analyzed did the case studies, we found out that the range of cases that would have a dropping effect was somewhere in the neighborhood of about 14%. So it's a small amount. There's a corresponding increase on the low income level, but there's a lowering on the people because of the fact that the income tax is taken into consideration, the graduated income tax is taken into consideration.
Thank you. Judge Lee, I feel bad you're standing. I can't stop looking at you. Why don't you come over here and have a seat with us at the front up here? You come on over here, Pete. Well, right here there's an empty chair by Josh Belafonte over here. You can sit with us right here. Well, we go. Any other questions regarding the child support guidelines? The tables. Yes, sir.
Just one point to address concerns raised by Representative Oliver. These child support guidelines, I believe that the law clearly states that they're to be the minimum, the base level, and that with evidence they are to be, the judge is directed to increase the child support in order to keep the child at the same economic level, I think quality of life as he or she would have enjoyed if the parents had stayed as a unified couple. Is that correct?
That's exactly right. An income shares model is based upon the premise that children shouldn't suffer financially because their parents don't live in the same household. So that's the underlying concept, and the basic child support obligation table is just exactly that. It's just the basic child support obligation, and that's why you can't compare the presumptive award under flat percentage of guidelines to the basic child support obligation, because that's not the presumptive award, nor can you really compare them in any meaningful sense, because the presumptive award under the flat percentage system was subject to deviations in any number of cases. So unless you really are looking at exactly the same kind of facts and exactly the same kind of deviations, it's just impossible to generalize. There's no question in my mind that there are going to be child support awards that go up and there are going to be child support awards that go down, because that's just the nature of how income shares is going to affect this.
So this is going to require a lot more work on the part of the judge in terms of, quite frankly, using his or her judgment.
It is very, very fact-intensive, meaning it will be much more work for the lawyers, in my opinion. It will mean that there will be a lot more accurate information supplied, because we'll look at actual costs related. Does your child go to soccer? Is your child a dance student? Does your child attend private school? You do look at standard of living issues, and this Senate Bill 382 retains 221's emphasis on the court having to look at the best interest of the child. So yes, The judges are concerned about the amount of work that this may take, but I can go ahead and address the pro se question. I think that in terms of pro se, 382 is a vastly better bill than 221. I mean, 221 is going to be difficult for lawyers, judges, and pro ses. 382 is a much clearer income shares model than 221. So the issue for pro ses will be worse under 221 than it would be under 382. There's a one or two page worksheet, and then there are schedules. And the way the schedules work is it breaks it down, and the way it will work on the calculator, in the web-based calculator, as well as, what's your gross income? You fill that in, and then it puts it in the worksheet. And then it asks, do you have prior child support orders that you have to adjust your gross income? So the schedules are designed to guide people to address each of the steps of calculating child support. And that was recommended by the Forms Task Force that Office of Child Support Enforcement, Judge Jackson Harris, Georgia Legal Services, and a number of other people worked on. I'm not going to assume anything, but there will be a computer at the courthouse with the program available, and be available in people's homes as well. If they have a computer, it'll be available in lawyers' offices, at the Office of Child Support Enforcement, and in addition, of course, it can always be done just with the paper, pencil and paper. So there will be both available. So anyway, I've probably gotten ahead of myself, but I wanted to go ahead and address that question because I think it's a very important question, and certainly, it has been one of those areas where judges, lawyers, and courthouse folks are going to need to think, I think, very creatively about providing the necessary resources for pro ses. In addition to the training that we're doing, Judge Key is the chairman of the training subcommittee. There will be an implementation guide similar to the kind of thing that was done in Tennessee. I don't know if you've seen that with the frequently asked questions. Did you want to comment at all about our conversations about pro ses or any of the training aspects and implementation aspects? Okay.
I do want to talk about training. That's a concern I think the legislature has in implementing the bills and getting everyone across the state prepared for this, but we'll get to that at the end of it.
Well, let me just kind of summarize what 382 does. It retains the income shares model that 221 has, the philosophy, the underlying policies. It's really a major reorganization. So as you read through it, it's now been reordered so that it starts out with the concept of gross income. It starts out with the concept of adjusting gross income. So each of the mathematical steps to calculating, it follows in that order. So in looking at the bill as you read through it, it will lead you to each of the next steps. In addition, there was nothing in 221 that actually told you how to calculate child support. And that was one of the first things we realized as we looked at 221, that there wasn't a real recipe in there. So 382 has a new subsection B in it, which is literally, it's just a page and a half of step 1, find gross income. Step 2, are there prior orders for child support or other adjustments, such as the 1/2 of the self-employment tax that has to be deducted for self-employment income? And it literally, I call it a recipe because it is, if you look at nothing else in this bill and know nothing else and don't want to know anything else, it will tell you what the steps are for child support. Again, I think a major improvement over 221, where you really had to kind of hunt to figure out some of those things. Importantly, 221 had a number of conflicts with other Georgia statutes. One of the things the Office of Child Support Enforcement has been extremely helpful doing is pointing out to us where there were statutes that govern Title 4D cases that 221 conflicted with. And so all those conflicts we have attempted to resolve by addressing the Office of Child Support concerns. For instance, there are no jury trials in Office of Child Support Enforcement cases, and they don't want to have jury trials. And so, by statute, they also are not permitted to get involved in custody and visitation disputes. And so that was a very important part of the recommendations in 382 to ensure that only two parents in the same case can can the court adjudicate visitation issues. There is, for instance, there were areas where the court needed more guidance. You all provided in 221 that a court could waive or reduce interest. You reduced the interest on child support from 12% to 7% and gave the courts authority to waive or reduce it. And language has now been included there to tell the judge, what do you have to think about to exercise your discretion? You balance the needs. Will this help collect child support? Will this be harmful to the person who has not received the child support? Those kinds of issues. We've provided in 382 a lot more procedural steps for things like you all had a provision for you can come back in 90 days if the court's imputed income. We figured that what you meant by that was a motion for reconsideration. And so it now sounds like something that lawyers are accustomed to. File a motion for reconsideration, the court can then schedule a hearing on that. In addition, that provision would permit a defaulting person who thought that the judge had imputed the income too high to come back in and say, oh, gee, really, I don't make that much money. I'd really like for you to set it a lot lower. Well, somebody who sat back and decided not to come to court, forcing the court to impute income based on whatever evidence the court had, we didn't really think you all intended to give a second bite at the apple to come in and try to get it lower. So we recommended in 382 that it's when somebody has evidence that somebody's income is higher than what the court found, that then you're entitled to come back. So there were areas like that that as we thought about them, we were able to include clarifying language or procedures. The definitions contained in 221 were largely drawn from the Tennessee bill, and many of those references were not consistent with Georgia usage or were not used consistently throughout the statute. For instance, the word caretaker was used in several different meanings, and it was very confusing. So we have refined the definitions so that they are not as they're not confusing and they're necessary to the statute. We've also, with your permission, this I think would be a wonderful thing. We've capitalized every word that's defined. So throughout the statute, if you see a capitalized word like adjusted income, you know that that's in the definitions, and you can flip back to the definitions and see, okay, what does that mean? What is work-related daycare? What is health insurance? I mean, those are the kinds of things that have made the statute more user-friendly. And we were told, Jill Travis told us, well, we haven't done that before, but it seemed to make a great deal of sense, so we've recommended that. Now, there are some areas that there are some substantive recommendations, although we tended to try to avoid those and work on the technical, clarifying, procedural, consistency areas, and I'm going to talk specifically about those areas because I want you to have an understanding of why we've made the recommendations. I do want to point out that this bill does contain some other provisions, not just related to the child support calculations, but there is, you provided for direct appeal last year in 221, and so this bill contains an amendment to 5635 because only 5634, which is the direct appeal statute, was amended last year. 5635 continued to say that these kinds of cases were by discretionary appeal, and Justice Carley had pointed out to us that if you don't amend both of those, that there would be a conflict. After you hear about the jury trial provision that we are asking you to consider in Senate Bill 382, you may or may not want to reconsider whether or not direct appeal is something you want to do. That would be entirely up to you.
Let me interrupt to tell you that that is a concern that we've had addressed to us. I'm going to be having someone from the state Supreme Court come over and also talk about the ongoing program that was started back in 2003, I believe it was, where they modified their, I don't think rules, but at least their actions with regards to acceptance of appeals dealing with divorce matters and child support. In fact, they now are pretty much taking every case except those they consider to be frivolous appeals, and having a ruling on it.
I'm sure that the appellate courts will want to speak with you about that issue.
Mr. Chairman, would it be appropriate for me to ask a question regarding that issue?
Sure.
Did the commission discuss the importance of direct appeal as part of its deliberation? Because I must admit, I'm very concerned about any notion of removing that direct appeal. I'd like to hear what the commission...
The commission really didn't take a position at all about direct appeal. It really wasn't an issue that the commission had concern about. We wanted to make sure that the two laws that govern appeals were consistent, and that really, once we did that, we moved on from the issue of direct appeals. I mean, that was just not something that occupied a lot of our time. Again, our hope had been to avoid getting into issues of policy that are legislative in nature. So, that wasn't an issue for the commission, I will just say. One of the other things that I think is important and that needs to be pointed out is that the worksheets and schedules that were just referred to, the 221 amended 1969 or whatever it is, that says the judge has to include certain things in the final judgment of child support, certain findings and things like that. Well, we've asked you to consider including in that it be a sum certain, because we believe that's what Georgia law requires. The child support award should be a sum certain and not just some, we'll have a percentage of your whatever. It needs to be an enforceable, collectible, known amount, and that wasn't anywhere in 221, so we recommended you include that. And very importantly, that litigants have to, and the judge, have to file the worksheets and schedules, and the judge has to attach the final worksheet to the judge's final order, and the worksheet will be incorporated. That worksheet then will be provided to the commission, because what the commission's intent is to track outcomes in these cases, track how the deviations are being used, track amounts. We've really started gathering the data through this commission by doing a case sampling in 11 counties, getting every child support order that was entered for the entire month of September of 2005 and subjecting them to analysis, finding, interestingly, that the deviation rate in Georgia was 40 to 50%, primarily for multiple households.
No surprise.
Not a whole lot of deviations were used, but multiple households was the major factor. And of course, a number of those cases would have been Title 4D cases, obviously. There were thousands of cases. But the national rate is deviation was 17%. So you can see that under the flat percentage of income statute, that in fact there was about a 50% rate of deviation downward. Which none of us had anticipated, and the economists were very interested in that. We did a case sampling study. No, ma'am, the orders all were downward deviations. There was about a 50% downward deviation rate.
Got it.
No, ma'am, this is the cases that are cited under the flat percentage of income. We gathered all of the child support orders entered in 11 counties that were chosen for their various diverse geographic and other aspects. All of those were analyzed, and it turned out that apparently the deviation rates under the flat percentage of income guidelines is quite a bit higher than the deviation rate average national.
You're saying taking the same circumstances in County A compared to the circumstances in County B, we were having great variations between what the courts did in those two cases. If you compare income size, children, households, etc.
No, what I'm saying is that in a vast number of the orders, there were deviations downward, either by the judge, by court order, or by agreement of the parties.
I see.
It means that if the child support is going to be $1,000 on the gross income, they lower child support.
Right. And the primary ground for deviation used in those orders, the one that came up most often was multiple households, either prior or subsequent children, obligations to other households. We pointed that out, but you will. It is really fair to make sure you understand that a number of these cases would have been Office of Child Support Enforcement cases. A number of those cases would have been consent orders where the Office of Child Support Enforcement would have recognized that somebody is already paying support for another child. Or right, exactly. Right. So, but there was just a significant usage of deviations under the flat percentage of income is the conclusion that it was fair to draw. To draw much more than that, we would have to engage in a lot more kind of analysis.
I think, Senator Harp, you wanted to add something?
I wanted to add one comment. Working with Dr. Vednar, I was led to believe, and I think we confirmed it with Dr. Vednar, that when we had a deviation rate as high as we do, that placed in jeopardy Georgia's receipt of the TANF funds. HHS, the federal HHS, indicated to us through Dr. Vidnor and others that when you have a deviation rate that gets above 20%, they begin looking at you and wanting to audit you. But ours was in the 40 to 50% range, which said we were way out of the ballpark. And that's one of the processes that will be corrected by 382-221 because of the fact that the orders are particularly factually sensitive, and because of that, they correspond with the scheme that is set up in 221/382.
Thank you. Go ahead.
The point that I was getting to is that we have begun collecting data in order to be able to understand what happens to child support awards in Georgia. We want to continue to do that, and so this filing of the final worksheet and providing that to the Commission will be a significant help because we've never collected this data before, and so that is included in 382. Now, I know I'm going through this pretty quickly, and I'm certainly happy to have questions. My intention was to sort of go through the statute in order, not in detail, because I know you all will do that at a later date, but to point out to you some particular issues that I think you may want to ask questions about. And what you should have is a section-by-section commentary, and that has... No, this should be in the packet that you would receive today.
We have it all in our folders.
That right.
And I commend it to all the committee members to take time the next few days to sit down and look at it, because we're going to be using this as a part of our discussion. Yes, ma'am, Ms. Oliver.
May I ask a process question?
Sure. We're doing this, just to give you an overview. I wanted Judge Abbott to come in at the beginning to speak to the committee. We're going to finish up with the House bills this coming Tuesday, I believe. And after we get through that, we can take our Senate bills, because we have a little more time, flexibility. We're not under the gun with the 30-day crossover staring at us. So then what I want to do is get back into Senate Bill 382, and we will hear testimony. I don't know how long we'll be able to go with hearing it, but I think I don't mean limit, but say we've heard a lot from last year, the pros and cons about which way to go. We've made a policy decision of the way we're going, and now I think addresses what we're doing through 382 as changes to 221. For the 382, you mean? Yes, ma'am. That will be some of the things we're going to consider. And I'm going to have Judge Abbott talk about these amendments that the Senate made to the bill that came through as far as starting 382 is taking the Commission's recommendations of changes put into a bill form as 382, and then it went through the committee and TANC. It got to the floor. There were some amendments two amendments on the floor. So I wanted Judge Abbott to also address those amendments. We could, because he'll be presenting the bill when we get ready to take it under consideration. Please, that's fine.
The useful thing about this section-by-section commentary is that it actually has comments that explain what the changes were and some idea of why. Also, you'll discover as you go through that there's some areas where we just say to you, did you mean to say and here or here. We weren't really sure. It could make a difference. Some other issues that maybe were brought forward by other people that we as a commission didn't adopt, but thought that you might be interested in knowing that these issues exist for you to consider. There are very few of those. These little color tabs of those. I don't intend to try to go through those today, but I commend this to you because I think it will be very helpful in reading through the statute. So let's talk about the more substantive areas where 382 does recommend changes to 221. Having said now probably way more than I need to say that the idea was to clarify and make 221 more workable, and that's the result is 382. But one of the issues that we really had to grapple with was the whole thing of jury trials. And you will recall that 221 removed jury trials from any issue except gross income. Well, first we kind of thought about what's the procedure on that. The parties present evidence on gross income, and then the judge is to hear all of the other evidence on child support and decide child support. Well, obviously that means a bifurcated proceeding, and in some cases the evidence concerning the child support deviations, add-ons, parenting time adjustment, all of those things, that in and of itself may take hours, if not in some cases days. So we thought about that procedural issue as being one that was going to be important for us to address. But then we realized there was an even bigger conundrum here. Under 221, the jury would decide gross income, and the judge would then make every other decision and make the final child support award, and then tell the jury, here's what the child support award is, because obviously the jury needs to know what the child support award is to decide all of the other economic issues. Needs to know, for instance, like whether or not to order the house sold, or who to give the house to, or how much alimony to award or not award, or who should pay debts. I mean, you can't decide all of those issues without also knowing that there's a child support award. Alimony can be a deviation factor to deviate from the child support award. The jury would be deciding alimony. So, upon the return of the verdict, you would have the jury returning its verdict as to alimony. The judge would have decided child support. Now the judge may think, if I had known the jury was going to award that amount of alimony, I would have deviated from the child support. But now, if the judge deviates from the child support, maybe the jury would have done something differently from alimony. So we realized that it was just essentially a catch-22. I mean, it was, at least in our minds, a very difficult to reconcile problem. And we ran this past lawyers, other judges, and so ultimately the suggestion in 382 is to return a number of the issues of child support to juries and to accommodate the issues about, well, gosh, the jury can't, we don't want to have to give them the basic child support obligation table, and we don't want them to have to do these kinds of mathematical things. The idea is this: the jury decides gross income, informs the judge about gross income in a bifurcated proceeding. The judge then looks at the table, comes up with the presumptive child support award, which is the basic child support award plus health insurance plus daycare, adjusted by the parenting time, which only the judge could do anyway. Then the jury decides all the deviations, and that ultimately allows the jury to consider whether or not to deviate based on an alimony award, and that resolves that conundrum. So that's our recommendation in 382.
Example of your deviations would be the issue of payment of child care.
No, that's not a deviation. That's a mandatory add-on.
Right.
The deviations would be people at high income, people at low
Dance
income.
lessons, talked about.
Right, special expenses, which would include things like soccer camp,
Special
Boy
education
Scout
needs.
expense, yeah, all of those kinds of special education needs, extraordinary medical needs. We've suggested that you re-include the ones that were in our current law that weren't contained in 221, like if a party is providing a home for the custodial parent and child, the party who gets the child care credit and dependency exemption, that would be included as a deviation. And while I'm on that topic, we also realized there was another statute in Georgia that, quite frankly, I've never had argued to me in any case. There's a completely separate statute, 19634, that says that if a party provides life insurance for the benefit of the children, that's a mandatory adjustment of child support. You know, there's a lot of stuff in these books that you all help us create. So we realized that there could be potentially now another downward adjustment to child support that would be a mandatory thing that nobody else would have considered. So we're suggesting that you amend that statute and make that a may be a downward deduction, and we have that recommendation for you, and that you make it a deviation that the trier of fact could decide whether it's in the best interest or not. I mean, that's ultimately the deviation comes down to this. Is it in the best interest of the child? Similar to our current law, the court or fact finder has to decide that. So in a given case, the jury, if the only deviation factors that applied in a case were, whether or not to deviate to add private school tuition and for special expenses, then you would charge the jury on those deviation factors. I mean, obviously not all deviation factors would apply in every case. So, again, this is going to be a matter of the Council of Superior Court judges coming up with really good charges on this. We've had some great help from the Family Law section on creating special verdict, special interrogatory form to try to allay concerns about this being too complicated for a jury. Of course, they decide deviations now. So it sort of puts a good bit of the child support back in the purview of a jury when there is a jury. And if you will just remember that the reason that we did that is because of this alimony child support thing. And if you all have a different idea about how to fix that's fine, but we couldn't think of any other way to fix it. So the other thing that we wanted to make very sure was on the willful, involuntary, and underemployment section. Last year there was a lot of concern about making sure that the court could consider that someone had historically been a stay-at-home parent, and that didn't want to be penalizing somebody who is voluntarily deciding to be a stay-at-home parent, that they automatically have to have income imputed to them because of that decision. And you've specifically provided that where the party's taking care of a 4-year-old child or younger, that the court should consider that. And we have attempted to, I think, strengthen that provision by it was chopped up into several different places, and we put it all together in one place and made it clear that the court has to exercise its discretion in considering whether or not to impute income to someone who's taking care of a child or a disabled relative or some other factor like that. And we've had a number of questions and concerns from people about that are fearful that someone who is a stay-at-home parent or a caregiver for someone is going to automatically have income imputed to them. And I think it's clearer in 382 that it's within the court's discretion and that the court has to exercise its discretion in that regard and make the appropriate findings. I've already mentioned to you that we realized that the motion for reconsideration within 90 days, we assumed that you didn't mean by that the judge had to hear it within 90 days, but that the judge should schedule a hearing so long as the motion was filed within 90 days, and would only be if the other side says that income should have been imputed higher, rather than somebody coming back in to try to get a second bite of the apple and say, oh, no. Sorry, I wish I'd come to court the first time because I could have shown you that I don't make that much money. So that fixed that. The following bill is the parenting time adjustment. I'm going to speak about that in some detail in just a moment. I don't think we made any major changes other than clarity kinds of things to the mandatory add-ons of health insurance and work-related daycare. As to deviations, I've already mentioned that we've added several. A parent's extraordinary medical hardship had not been included as a potential basis for deviation. The non-custodial parent's payment of a mortgage or provision of a home for the custodial parent. The life insurance matter, I mentioned that. The child care and dependent exemptions. And then let me talk now about the self-support reserve. We've already talked about the fact that the tables, quite frankly, to my surprise, since the long-time criticism of flat percentage was that it came out with awards too high at the low end and awards too high at the high end, that without appropriate deviations, those awards were out of kilter from other states' awards in that regard. And that was, fairly, you could demonstrate that fairly easily by looking at awards across the board. But in any event, they did come out higher, and many states addressed the low-income obligor by ensuring that obligor who may be at the federal poverty level, that they have that amount of money sort of set aside, that they at least get to keep. I think it's around $900 gross is the federal poverty level, which a month certainly seems like very little money. So there is a formula now provided for that, so that a person who makes very little money, the court can exercise its discretion, or the fact finder can exercise its discretion, and use that formula to award a lower amount than would be indicated by the table, but not lower than $75 a month. I mean, it should never zero out, no matter what the income is, because obviously you shouldn't have children that you pay no support for. So this is not a inventing the wheel kind of provision. We looked at many states' provisions, as we did with many aspects of this bill, and got advice from Dr. Benor about this as being one that's fairly easy to use. Adding another formula to something that's already got a lot of formulas we were hesitant about, but that seemed to be the best way to address the situation of the fact that low-income obligors awards could potentially have been higher. And it is completely discretionary as to whether or not to use it. It's not mandatory, but it's set forth in the bill for your review. One of the other provisions that we spent a lot of time looking at was the involuntary loss of income provision. You all may recall that the initial hope was that if somebody lost their job involuntarily, that the reduction in child support could be made retroactive back to the date of the loss of the job, and it was made clear that that would violate the federal provisions, that you can only make it retroactive back to the date of service on the custodial parent. But it didn't provide any guidance. For instance, what if somebody intentionally involuntarily lost their job, just didn't show up for work, got fired, and tried to claim that they needed a reduction in child support? So borrowing from the employment security law, that it would have to be without cause. In other words, somebody's laid off, or there's a strike, or there's some other thing that's out of their control, and we suggest that you add that language in order to prevent the court from being in a position of reducing child support where somebody has obtained a
good point
termination.
Mr. Lindsay.
Regarding that, because I've been thinking about this and I'm worried about it. We're taking care of the non-custodial parent if they involuntarily lose their job, to be able to reduce the child support back to the time that they can. But since we're dealing with income sharing, and we're supposed to be looking at the income of both parents, what happens when the custodial parent involuntarily loses their job? Do we have any type of mechanism in the law at this time to help that person out who may need, quite frankly, an increase in child support as a result of their involuntarily losing their job?
I know that
Do we have anything in place, and should we have something in place for that?
Right, I'm looking for the
It's
page.
for both parents. It's either custodial or non-custodial parent loses their job.
Yeah.
Okay, so
Does
that's good.
both.
So if the custodial parent, thank you, if the custodial parent loses their job, they can file, and any increase in child support
That's
as a result
correct.
goes back to the time of filing. Okay, good.
It's actually
Both
back to
ways.
the time of service.
That's time of service. Thank you.
Jill, do you know what page it is in here?
Toward the very back.
Yeah, that's what I thought. I'm just not finding it.
We'll get to it. We'll go
Right.
ahead and we'll find it.
Right.
I didn't
Yeah.
want to forget
We'll let
that.
Jill look for it while we,
Section J.
6?
There's not, it's not one document, it's not a page, no. Section J. It's subsection J.
J, okay.
I'm sorry.
That's after I, that's after deviation then. Deviation's I.
Right. I think
That was toward the end, I remember that. Here we are, whatever.
are you
J is on page 26, involuntary loss of income.
I think it's just missing
That's it.
from my book is the problem.
We're doing it for the bill itself, Judge Abbott.
Oh, okay.
All right.
You know, one thing I'll say just while we're looking, I do like the way it's now outlined as far as Section 4, putting in 19.615 in a much better readable form, logically flowing, provision after provision, and from the definitions right on through, the calculations,
Right.
and then the things that will be considered by deviations, example.
Right. And as you're reading it, and you think, well, what happened to that section? Just keep reading
It's there.
because you'll
Just
find
different-
it. It's just in a different place.
Much easier
I
to
don't
read.
have what they have, so I just don't have what they have. The
You want a
bill's
copy of the
in
bill, Judge?
That'd be great. I just haven't got one yet.
Yeah,
Thank
there we
you.
are.
I don't
You
have a
got
folder, so I didn't get a folder. Okay. Since I don't have that in my bill, is there anything else about involuntary loss of income that you want to mention?
Well,
The phase in.
Phase in.
Right. Yeah, thought
We
that it
have
would be important
modifications after
to
that,
provide for instance, say that somebody's paying child support along the way, and the court has a hearing 3 months, and then it's going to be made, the reduction is going to be made retroactive for a 3-month period, rather than reducing it all at once, and perhaps the custodial parent then having like pull money out of his or her pocket to pay back. Suggest that you consider phasing it in over a period of time so that the impact on the custodial parent is lessened by the retroactive aspect of it, to ameliorate the impact. I think that might be about it on involuntary loss of income. Oh, and we did ask that the court expedite these hearings, that give the greatest consideration to expedite them, so that you don't have that situation. You don't want to have a year later, all of a sudden, okay, you're going to have $400 a month reduced off your child support, and all of a sudden, the Office of Child Support Enforcement and custodial parents are having to, really figure out, well, where's that money going to come from? So we thought that really needed to be addressed. There is no other state that has a provision like this, and so we couldn't look anywhere else to find any sort of resource material for how to do this best. And Office of Child Support Enforcement obviously has some significant concerns, because many times the custodial parent's in another state. Recoupment issues for the office would be, really virtually impossible. So we tried to make this as workable a section as possible. And I appreciate your question, because that was a good reminder to me. That brings me to the modification section. The modification section. Oh, sure.
Yes, ma'am. Yes, sir. Go ahead.
Judge, I was just wondering, in terms of, you talked a little while ago about jury trials and items that would be heard by a jury. What about in these 4D child support cases? Currently, there is no provision for jury trial in those cases.
Right.
And that is an issue, actually, I had been looking at independently of this. But if you're going to bring in these guidelines and they call for jury decisions on these issues, what are you going to do with those?
This 382 specifically says that it wouldn't apply to Title 4D cases.
Why would we not want to apply it to 4D cases?
Because right now your current law does not provide for jury trial by statute, by constitution, or by common law. In fact, your current law, other existing law, says there is not a right to a jury trial. So we just made it consistent with those laws. Yeah, I mean, you would have to go back and change those other statutes in order to create a jury trial right in those Title 40 cases.
Is there any justification, though, for treating those people differently than you would treat people that would be covered under this bill?
Well, I'm not sure why there's not a statutory right at all. I mean, obviously it had something to do probably with the policy decisions that were made by the legislature that decided not to create a statutory right, and there was no constitutional right, and this is just one of those areas where it's only by statute. So I don't know that I can answer this question. There may be rational basis for it, given numbers of cases, agency issues, the fact that the custodial parent is not frequently in the state of Georgia. These are assigned rights to collect support for children. I'm sure that the Office of Child Support would be glad to give you many, many explanations for what their issues would be with jury trials, but I'm not prepared to address that.
All right.
Can we move on to modification? Okay. The modification section of the statute has been reordered and clarified substantially. There is a technical issue that we discovered after 382 was passed by the Senate that needs to be corrected. You remember that you set a threshold, and we talked about it last year about what kind of, you shouldn't just be able to come back to court just because there's new guidelines. I mean, this is a circumstance that will allow you to come back to court, but only if the award is 15% more or less than the award under the new guidelines. Well, you can't really determine what the new award will be under the new guidelines, because you have to know both parties' incomes, you have to know all these other things. So what we did is we said compare it to the basic child support obligation table. But what we left out was that you would only compare it to what the non-custodial portion would be of the basic child support obligation. Obviously, you wouldn't compare it to the total, because that's not what the child support award would be based on. It would only be based on the non-custodial parent's pro rata share of the basic child support obligation. So we've made a suggestion that you correct that technical issue, because you will find that every single order in the world would fit within that 15% category based on that mathematical error, and so we would ask that you please, here in the House, correct that.
Yes, sir. Mr. Lindsay?
One other area of concern, I was wondering whether or not y'all considered this, that I had in terms of the 15%. It's one thing to have 15% deviation when there's been a full adjudication by the court before underneath the existing guidelines, and now the court has to reconsider its ruling. But as you well know, most child support orders are a result of consent, in which there's a lot of give and take between those two parties. Yeah, I'll give you $10 extra a month, but I want the Naugahyde couch. I don't mean to be facetious, but there's a lot of give and take that goes on in reaching that. And so I'm curious whether or not y'all had any thoughts, or whether you have any thoughts as to whether or not we should have two different standards. One for where there is a contested, whether order as a result of a contested hearing, which I think 15% is an excellent place to begin, but whether or not there should be a higher threshold where there was previously a consent order.
We didn't talk about that specific remedy, but there was a great deal of concern and discussion in the public hearings, a lot of concern about modifying cases where somebody may have bargained away alimony, for instance, in order for child support, a not infrequent thing because of tax issues. Someone may have bargained away other valuable rights, interest in retirement, and other kinds of things in order to get somebody to agree to pay child support. So that has been a major concern, and although we didn't discuss having a different threshold.
How's that going to show up?
Pardon?
How's that going to show up? If it's in a consent, the parties just said, okay, you don't get alimony, so I can get a full write-off of something. You don't have to pay tax on this, so we've increased it out. A child support payment, there's nothing in the document, the agreement itself, or the order of the court that acknowledges that fact. So how are you going to do it?
That's exactly why I'm concerned about a mere 15% threshold, because it's not showing up in the orders that then perhaps there needs to be a much greater deviation than 15% in those limited cases where they're dealing with consent.
You have in your packet Tennessee's emergency rule about modifications. Tennessee really tried to protect litigants and courts from a deluge of modifications, or people who maybe had just finished a 2-year bruising battle in court and finally gotten done with it, and all of a sudden they're going back to court a month later because of the new guidelines. So Tennessee has implemented an emergency rule that adds several other layers of threshold before you can get back into court. Not just that there's a difference between the prior award,
this documents.
Right. Well, one of the real important, right?
That's one of the chilling effects of undoing it.
One of the important things that it was clear that by adopting and borrowing from Tennessee, Georgia's traditional modification law had not been tracked in the statute. So even though the 15% more or less threshold may get you into court, then the court still has to apply existing modification law, and that all got pulled back into 382, so that the court still looks at, has there been a change in income, has there been a change in the needs of the children. The court is going to base it on current income levels. So somebody whose income has changed, has gone up, I mean, there could well be some unintended consequences from filing an immediate modification simply based on the guidelines. We tried to make that clear that that's not the case by making it more or less a jurisdictional threshold. We didn't take the modification statute and say we think you should redo this completely. We took what you all did in 221 and attempted to make it more workable and clearer. I mean, I think modification is an area that deserves close scrutiny.
You limit yourself not getting into policy decisions.
Unless we were asked,
right.
And specifically with regard to parenting time adjustment, Senator Harp asked us to address that because of the information that was supplied by Policy Studies, Inc. And with the self-support reserve, we felt that was a policy issue, but an important one that we needed to bring to your attention. I can't really think of a whole lot of other areas that we made what I would consider to be policy recommendations. So, but as to the modification statute, needless to say, I think that's an important area for you all to look at, and that's why we provided the Tennessee emergency rule, so that you could look at how Tennessee has addressed that. And would be happy to provide any other information in that regard as well.
All right, go ahead.
Are you okay? Then I think I'm ready to go ahead and talk about parenting time adjustment. And what I thought I would do is, because clearly this is the most controversial aspect of this bill, and so, although I certainly want to explain why we recommended in 382 that you consider the changes that you did, my comments here are primarily to just sort of return this to a more academic level and discuss the economics of how the idea of parenting time adjustment ever arose in child support law. Now, I think that a lot of people have thought, well, parenting time adjustment is new in Georgia, and it's linking visitation and child support, and that's not something that we've ever done. And although it is most certainly and definitely the law that you cannot stop paying child support simply because you're not getting visitation, and in those ways child support and visitation are clearly not linked. Child support and visitation have always been linked in Georgia because we've always had a parenting time adjustment. As with many states, we've done it by deviation. There are 5 or 6 different methods for parenting time adjustments, and Georgia chose to do its by deviation. So when a court grants extended visitation to the non-custodial parent, the court has always been authorized, and in fact, I'm sure many judges, I know I frequently have, do a downward adjustment of child support because of the economic notions that underlay the idea of parenting time adjustment. And I brought the National Center, National Conference of State Legislators. I don't know that I have enough for everyone, but this is just a very basic kind of outline of what a parenting time adjustment is, what different states do, what the pros and cons are, and all of that. And I thought that might be useful to you to have, because I think one of the things that I recognized as we were going along is that calling it parenting time adjustment, giving it a new name rather than calling it a deviation for extended visitation, made it seem like something that was very novel in Georgia, and I just think that notion needs to be dispelled because it's not new. One of the most important things that 382 does is it makes clear what 221 didn't, and which has caused lots of concern. The parenting time adjustment is based on the court order. It's not based on what parties do. It's not a matter of people going out there and saying, well, I'm going to count this day and I'm going to count this day, and now I'm going to reduce how much money I pay every month. And there was enormous concern on the part of the public that that's what 221 meant. We believe, and I think it's implicit in 221, and it certainly is the only way parenting time adjustments are done anywhere, is that you count the time that's contained in the court order. And so 382 makes it very clear. So there's only one way to determine a parenting time adjustment. That's either the parties agree to a certain amount of visitation and the days are counted up, and then that's incorporated into the final judgment, or the court, in a contested case, awards a certain amount of visitation, and then a parenting time adjustment can be considered. It's also important to note that people seem to consider a parenting time adjustment to be an automatic. If you reach a certain threshold, you get a reduction. In fact, 221, and carried forward by 382, says that it's a presumption, which can be rebutted by evidence. Now, I hate to give case scenarios because as a judge, I'm going to get this case tomorrow and I'm going to be told, you said that, judge, and that's the way you have to rule now. But you can imagine a scenario where a party is awarded substantial visitation, but the party doesn't actually expend any money on the child. The party lives with his or her mother. His or her mother provides the care for the child. His or her parents. We see some very young people having children, getting divorced, returning both of them to live with their parents, and they're not incurring expenses to take care of that child while that child is with them, or not incurring much at all. That would be the kind of argument you would hear from a lawyer to say, look, even though 120 days has been awarded, I am still bearing all the costs because this parent is really not incurring any cost. Of course, those grandparents might have something to say about it, but that's not contemplated in this child support bill. So those two notions, I think, have merit and need to be clearly understood when you consider anything about a parenting time adjustment. So I think the important language in 382 is that it is what is contained in the court order, and we put it in there in a couple of places. Now, how did the whole idea of parenting time adjustment arise? Well, a number of years ago, Laura Morgan wrote an article, and Laura Morgan was involved early on last year in the process of trying to educate us about all the different kinds of ways that child support can be calculated, and came here to the Capitol and spoke to a large group of people. She wrote an article about what to do about child support in shared custody cases. And as she put it, in that case, when you have parties who have essentially equal income, you have to do something to adjust the child support downward in recognition of the fact that the cost of raising the child then gets shifted between the parents because of the substantial amount of time that the child spends in both homes. So essentially, if you look at the cost of raising a child as being a finite amount of money, now obviously it's not just the basic, it is also everything else parents do for their children. It's not just driving them to school and paying for the gas and paying for the heat and paying the rent and food and all that stuff. It's everything. But if you look at that as a finite sum of money, then the concept of a parenting time adjustment is not a credit for visiting. It is a recognition that the more substantial amount of time, such as in shared custody, a child spends with the parent, the more that the money needs to be divvied up differently between the parties. And income shares makes that very clear, because in that basic child support obligation table, it shows you that basic amount of money it takes to rear a child. And that is the only amount of money that should be adjusted by parenting time adjustment. And that was not clear at all in 221. You don't change health insurance, move it from one side to the other, or reduce the amount the custodial parent gets to reimburse for health insurance or daycare or soccer camp or all of that stuff, because those are fixed expenses. Those expenses don't change no matter how much time a child is with the non-custodial parent. So you only adjust that basic thing, and you only do it based upon the fact that somebody spends more than what people call a standard visitation, to the extent that there is. I think the standard is different probably in every circuit. But the concept that Laura Morgan addressed was how to divvy up the cost. And this is an important point. You remember Representative Lindsay pointed out that the whole concept of income shares is based upon the idea that the children should be treated financially as if both parents lived in the same household. The parenting time adjustment is the only area in an income shares bill or in a flat percentage or any other child support bill, because they exist with every form. I mean, even Wisconsin has one now where we got our original child support guidelines. It is the recognition that in fact there are two households, and that there are some expenses that both have that are fixed, and that custodial parent's still going to have those expenses no matter whether the child is with non-custodial parent 1 day or 200 days. And then there's some duplicated costs. And when those costs of feeding a child and all of those things start becoming substantially part of the non-custodial parent's responsibility, then that's when a parenting time adjustment is considered appropriate in, I think, all 50 states. And that's why I brought you the National Center for State
At this
Legislators.
point, we had a change from the Senate from what was brought in, which was the original 90 days to 120 days.
Right.
What is the position, if any, as far as the commission and your committee on that point of it?
Well, there needs to be some history on that. You all remember that in the original 221 last year, the Arizona model for parenting time adjustment was used, and if it's from 0 to 4 days of visitation a year, there was a small adjustment to income from 4 to 8. And I think we all looked at that and thought, gosh, that you're going to give an adjustment for 0 to 4 days? How is that actually? Well, what ultimately happened is that Tennessee's law went into effect, and we had adopted Tennessee's law, and it was started at 100 days, I think, and or at least that's what we decided. It would start at 100 days. Y'all decided it would start at 100 days. Well, Tennessee's law has not worked well at all for this reason. It has increased litigation, custody and visitation litigation, because of what they call the cliff effect. Now, this was brought to our attention through Dr. Venor, who met with Senator Harp and said, you all need to try to fix this before you get into the same mess that Tennessee's in, which is now having to repeal it and completely redo their parenting time adjustment because it has bogged down and caused people to litigate more. And because of this cliff effect, the higher the threshold, the more somebody is going to try to fight to meet that threshold, even if that threshold is unrealistic for them in real life, in order to get that adjustment. That's the sort of notion of why it increases litigation. If it's easier to get an adjustment, still you have to have substantial visitation, obviously not just 4 days, but if it's easier to get it, there tends to be less litigation. So for instance, in Arizona, parenting time adjustment has not been a big issue for parties. This is not something they litigate over. In Tennessee, this has been a big issue. I've brought you the Tennessee Department of Human Services Child Support Income Shares Advisory Committee, summary of their recommendations for their changes, where they are discussing the department's adoption of new rules on parenting time. So after hearing from Dr. Venor and looking at what was going on in Tennessee and having the concern about the increased litigation issues, the other important point about parenting time adjustments is it has to be based on economic factors. Arizona's is done based on an economic study. Tennessee's was done based on an economic study. We had to be sure that whatever we did, an economist told us it was correct based on our tables. You had to look at our tables, our figures, and make sure that the percentages were appropriate to our tables. So in order to alleviate this cliff effect, what we recommended in 382 is to add overnights and go to 91 days, I think. And that's essentially the information that we were given, is that we had...
And overnight, suppose at 12 hours. So you have a parent keep a child from 7 o'clock in the evening to 7 o'clock in the morning, still got 12 hours, takes the child to school.
Right.
But you're looking at based upon there being an overnight time.
Well, what we suggested was that you keep that calendar day thing, and then if there were an overnight, you can't double up on them. If there were an overnight that wouldn't have qualified for a 12-hour, then you can add that. And now here's the classic scenario. Friday to 6 at Sunday at 6. Well, that's not going to be, 3, you're not going to count Friday night in that because
Sunday.
It's not a 12 hours in a 24-hour period. So that 6 p.m. Friday to 12 p.m. Friday wouldn't count unless it was counted as an overnight, and that's just what we said, and it's all in 382.
The Senate didn't change that.
Yeah, they took all of that out and put back in the Tennessee law.
Put the 12 hours back in?
They put the 12 hours in,
the
took
bill
out
came in
overnights.
382 with the overnight visitation.
Right.
But the amendment came back, or the amendment took it back to the 12 hour.
And that's why we did
you'll
it.
take out.
Okay. Take over for a minute.
Well, right, but I have a question.
You're the man now.
Because I'm, thank you. You lost me, and I if you could, Judge, just take a step back and just try to run this by me one more time in terms of how we calculate the time. Underneath your original proposal of 382, just sort of walk up through it.
Yeah.
I apologize.
So, for instance, let's say you have an order that's every other weekend, alternating holidays, week at Christmas, spring break, a month in the summer. Well, the first thing you're going to go do is count all the time periods there where a non-custodial parent has a child for more than 12 hours in a 24-hour day. And you're going to mark out all those days and count those up. And then you're going to look if there are any overnights that are not already included in there so that you don't, count one day twice. Okay. Are there overnights like Friday at 6 to Saturday at 12 p.m., 12 a.m. that weren't otherwise counted? And then you add in those overnights. And there will be a few of those every year, essentially, that wouldn't have counted just because of the starting time. Now, lawyers will probably start doing things like, changing the times. I mean, that the time element's going to be quite interesting. I mean, drafting settlement agreements is going to be very interesting because it also includes time that the child may be at school, so long as that parent is the one under whose control the child is. So, for instance, if you return the child Monday morning, then you're not going to get credit for that whole day at school. But if you return the child 5 o'clock in the afternoon on Monday, you get credit because that's more than 12 hours in a day. So you first count all your more than 12 hours days, then you add the overnights, and you see how many that is. Now, that's still not going to include like Wednesday from 6 to 8 or whatever. That's a common thing. We take them out to supper or something like that. That's not going to count in there at all. There's not going to be any credit for that time. There are going to be issues for people who have shift work and things like that who really can't get to either of those. And you will see in this Tennessee material that that's been a real concern, that there's some people who have certain kind of work hours where they never have a child overnight and where their visitation gets broken up so they don't have more than 12 hours. And that's a whole other issue we may have to deal with in the future. Once you get that number, if that number qualifies the person for parenting time adjustment, you just look at the number of days and then you reduce the child support by the percentage associated with that number of days. If it's 100 to 121 and it's a 10% reduction or whatever. Of course, that would be after the court has determined, in fact, that it's appropriate, that the person, in fact, has borne some kind of expenses related to the child, because it's a two-prong analysis. That's 382. 382 before the Senate.
Let me explain the change, and then we'll do the question.
You want me to explain the Senate amendment?
Yes.
The Senate amendment is Tennessee's law, which is in 221, except that it increases the visitation threshold. So you don't get a parenting time adjustment until I believe it's 121 days, and you count days by more than 12 hours in a 24-hour period. And it doesn't include overnights. And it made that visitation threshold even higher, which is exactly what we have been told and what Tennessee has experienced as being a problem.
Okay. And I'm going to get to Representative Oliver, but just one. Friday 6 p.m. to Sunday 6 p.m. Any difference between how 382 was originally written and how it is now in terms of how many days would that be?
That would be 3 under 382 as we originally proposed it. It will be only 2 under the Senate amended version.
Okay. Now this is the reason for some confusion. That's 48 hours. It doesn't make a lot of sense to the person walking around on the street as to why that would be 3 days.
Well, we didn't call it days. We called it parenting time units, which is different kind of concept. I think you're absolutely right. There's the counting up these things is it's not consistent with our own notion of days. Just like saying a day is more than 12 hours in a calendar day, it's not intuitive to members of the public. I mean, that's why we changed the naming of it, because the word day is sometimes used in the statute to mean a day, and sometimes it's used to mean only if it's more than 12 hours in a calendar day, and a calendar day is defined. So there was confusion about the use of the word day at all to start out with, and we've had a lot of explaining about that, which is kind of sad that we've made day a confusing word, but that was another issue that we wanted to address in 382.
This parenting time adjustment does one other thing that I think is significant. It encourages the involvement of the non-custodial parent in the child. And there have been 4 major studies that have been conducted by other states, one Midwestern state and 3 Western states, that by giving this effect, that has the effect of increasing the payment of child support. And if you'll recall, when we write this bill, we're addressing not just the wealthy folks who have the capacity, but a lot of people who are on the cusp of the cutting edge, the lower income people. That's why we have $1.5 billion of uncollected child support. And the policy behind this was to try to get that non-custodial parent involved in recognition, and by that economic recognition, that has the effect. And those, as I said, those studies indicate that. Again, Dr. Vednor was gratefully helpful to us in that, but that was the world behind it.
That's the basis for it. Whatever you all decide to do, I mean, that's ultimately up to you all. I just wanted to explain some of what I've learned since last year, because I really didn't understand that there was an economic basis and that this had been something that had been studied and analyzed, and obviously I've had an opportunity to learn a lot more about it now. I wanted you to understand why the recommendation was made in the original 382 that we did. If the Senate amendment has not been looked at by an economist, you may want to have that done, because what we learned is that these numbers are not just numbers. These are based upon analyzing the data that was presented in our table. So somebody like Dr. Bernor, or somebody, if they haven't already, economists may have proposed it, but that was one of the things that we put it through 2 economists to make sure that the numbers were valid.
Ms. Oliver, you had something, Brenda?
I really don't see how the pro-se person's going to figure this out.
But remember,
We have a parenting time in our annual, and the end of the judgment staff deviated 50%.
Yeah.
Kind of, and think well about this might be worth it. In my area, 90 to 120 years of school. And that's one of the reasons that I see the parenting time limit as the reality of reducing child support.
But is it 90 to 120 days based on this definition, or is it you're just counting any time they have visits? Because that has been a source of great confusion, is how you're counting.
I still understand it. I'm going to understand it at some point, but I don't want to. But is it correct that you're doing both overnights and parenting units, and no understanding covered in that percentage?
I can't answer no other states exactly what Tennessee is proposing to do, and I think many states just say 25%. If you have 25% of the year, and so you just count up all the amount of time every hour. Many states count up quarter hour. Every 4-hour period. This is done, and many states also then use a cross-credit system where you add a multiplier to the basic child support obligation by 1.5, and then you count the number of days each has, and you give a cross-credit back, and that results in even greater reductions of child support than the recommendation in Senate Bill 382. On the pro se issue, one of the things that the judges are really trying to think through, and I want to talk about the counting days too, is that we are really going to have to think about trying to set up resource centers everywhere now. This is going to be an important need, and judges at meetings have said, is there going to be money for us to set up resource centers? Fulton County is fortunate to have the Family Court pilot project. Not a lot of counties have those kind of resources, but I really think it's going to be very significant to provide a great deal more information to pro ses. And in addition, I think that the Uniform Superior Court Rules Committee is going to have to look at adopting some rules that maybe will require people to have status conferences at a certain point with each other to share information. You can't calculate child support until you have everybody's information. You could have somebody come to your office right now, and you could tell them what the child support is probably going to be, right? You don't need to know a whole lot of other stuff other than what the gross income of the obligor is. So this is going to be an important area for us to work on in terms of the implementation guide to assist pro ses and lawyers and judges in the data collection. And this is a major focus of what the Commission is going to be doing. We have got training set up right now. April 12th, we're training people from throughout the state to become trainers themselves so that they go back to their local communities to start this training. April 27th is a statewide broadcast from Georgia Public TV all day long, lawyers and judges training. There are 5 sessions set up throughout the state for Superior Court and Juvenile Court judges right now. I feel like I've seen whole new parts of Georgia now. Yeah, Columbus is a great town. So we're poised to inundate the judges and lawyers with this. And the Office of Child Support Enforcement, which has created the electronic calculator, has been working on the whole concept of making this as user-friendly as possible.
Some of the counties and the courts are going to, what I call, hit the wall, realizing now we got to do something, which they weren't doing in the past. But I also say you got 30 states that are doing it.
36.
So 36 now. 36 states doing it. So why are they able to do it, and we're saying we're not able to do it?
Well,
and they have pro ses as much or more than we do.
You might want to look at California's calculator sometime because it is dramatically more difficult. I think it's California's than this one is. This is by a long shot not the most difficult income shares law I've looked at now.
Great, thank you. Anything further we have talked?
You have those technical changes that we think really definitely do need to be made. And any other, I'll be happy to come back anytime or to answer any other questions at any point, and contact me at my office if you like as well.
Well, Judge Abbott, we're most grateful for the time you have spent in the past working with us, your time today to come up and visit with us, and we will be, I'm sure, still calling on your expertise and insight as we get into the putting together whatever may come out of this committee as far as the bill.
I want to thank the legislature for giving judges and lawyers and citizens the opportunity to serve on this commission and work together with you on, trying to make this the best law we can possibly make it. It's been a great opportunity. Thank you very much.
Thank you, too. Judge Lee, do you want to add anything you want to add to the discussion?
You covered everything.
We're glad to have you with us today, too.
Pleasure.
Thank you.
We're going to, at this juncture, terminate the review and presentation on 382. My suggestion will be that we're going to probably take this up as we get through the crossover day, and we're going to proceed at this point with the consideration on House Bill 931.
Thank you, Mr.
Thank you, too. Glad to have you with us today, Senator.
Thank you.
Yes, sir.
There is a more affirmative statement that the commissioner did not have this, however, which is something they brought to their attention. So that's
Okay.
But yeah, I put it on there if you're interested. You can,
Not yet. Not yet.
yeah, I
really made me look good.
I'll listen to him. I'll listen to him. We're going to 931. You might want to inform anybody who's outside they want to come in. We're going to be considering 931, House Bill on 931. Yes, sir. Well, not 1, 2, 3, 4. As Miss Oliver gets back, and five is a quorum. Yeah. And also Mr. Lindsay. Hello, Dr. Ferdinand. You got a committee, subcommittee?
Right, right after this.
All right.
What's the quorum on that, 3?
Yeah, I think so.
Yes. I think that's what we'll have.
If you want to leave the room as far as discussions on other bills, please do so. Please go ahead and exit the room. We're going to get on with another bill. We're running very late. Thank you. Well, working under handicap at the moment, we don't have a quorum. So Pam is?
She'll be off the phone.
All right. So until we have a quorum present, I can't proceed on the bill.
Can we leave all this stuff over?
Yes, sir. We leave it, your file. That's your file. Keep it all in there, and you'll have a chance to. Might be good to even pull it out and read it.
I will.
We have to get all telephones turned off. No telephones on in here. Please put them on a vibrate or turn them off. Hey,
How you doing?
Mr. Chairman.
how are you doing?
Good.
I got Judge Simpson coming. Hey, Mr.
Oh, he's
Hey, Mac.
doing a meeting.
1, 2, can't keep 5 in here.
Pam just.
I see Pam's here. Thank you. Hello, Pam. Is Lindsay coming back? I assume he is, right?
It's gone across the hall or something. I guess it's.
All right. Are you going to be joining us, Mr. Crawford? Or?
I'm sorry.
No problem.
If you've got a quorum, I've got to take Judge Simpson.
1, 2, 3, 4, 5. We just have just barely a minimum
I'll
quorum.
be back as soon as I can find the judge and we can leave.
Thank you.
Judge is leaving.
Okay.
Here comes Bo.
Thank you. Come on in. We're going to proceed now with House Bill 931. I think everybody's aware of the history of this bill. This is the bill I dropped in at the end of last year's session, just prior to our adjournment. The purpose of it is because we did not have what I felt in place anything as far as statutory standards on what would be the manner by which a tax commissioner could sell and transfer tax executions, and there were issues not only about the sell and transfer of them. There's also been the ongoing dispute of problems dealing with issues of notice to the delinquent taxpayer or person who then holds title to property. And past that point, we had the problems with trying to get payments made, as well as eventually, if there's going to be a foreclosure of the tax execution, questions about appropriate notice and the abilities to have the sale occur, and what happens to the funds even coming in post sale of the property. And we had a hearing, I believe back in August of this year, where we had a number of taxing officials come in, as well as individuals, talking about the bill and suggestions on it. One of the things that has occurred since the August hearing and prior to our starting the session, the Georgia Court of Appeals, in an action dealing with a Fulton County case, recognized that, in fact, what the legislature did back in 2002 was to remove the provision in the law that addressed the right of a third party to buy the tax execution, or in fact for the tax commissioner to make a sell and transfer of that tax execution. That decision, as I understand today, under appeal. But the problem is, I think if I'm reading the case, it was Judge Phipps did a very, thorough job looking at the law. He recognized that when we did away in 2002 with the language under Title 48 dealing with the sell and transfer, we were in fact stopping the ability that there did not exist an ability under Title 9, Chapter 1336, which has another area dealing with the transfer of judgments, and that did not in fact include the ability to sell or transfer tax executions because of a change that occurred historically back, I believe, in the 30s, where there was a separation of those two different types of judgments or tax executions. So, with that said, there is I think a strong need now to be sure we put something in place as a policy, because we do not have one in place. There are times where tax commissioners may desire to have a sale and transfer of the tax execution, and in order to do so, we need to have something in place as statutory authority, and also recognize the responsibility of the transfers. I'm going to go through and give you an overview of some things that we've done as far as the bill. It consists of primarily 7 sections. I want to talk about each section and give you a statement as to what that section will be covering, and from there we'll have discussions about the bill. Section 1 makes it clear what I was just stating earlier about the Georgia law as to the intent of the section, Georgia Code section OGA 9-1336 is not to address the sale or transfer of tax execution. There's a section B being added that specifically states that this section will not be applicable to tax executions. Section 2 of the bill breaks up the standard 90 days, which we now have in the law, dealing with the question of the 10% penalty. So there is a 4% penalty assessed when the bill actually becomes delinquent, while the remaining 6% of what is a statutory penalty continues to be applied at the end of 90-day mark. And the purpose of having this change made, one idea was to hopefully encourage the property owner to go ahead and pay the tax obligation prior to its due date. What is happening, as we understand, is a lot of people recognize that there is no real penalty, therefore there is no incentive to pay until close to the end of the 90 days having run before they go in and say, okay, so I don't know, what's the due date, Mr. Tilley in Cobb County? Is it October 1st?
That's not fair.
I got you off guard. I know in, say, Fulton County, it's October 15th. So using that, taxpayers realize that they can go up to as late as January 14th before they're required to pay before that penalty is assessed. So there was a suggested change here as a means of putting an incentive in place, and that's why we had that change. In Section 3, this creates new definitions of what we call due diligence. This is the area that gives authority for the tax commissioner, who may have the right, let's say, but he does have the right, he's not required to sell, but he may sell and transfer tax execution. So it gives that authority to the tax commissioner to sell or not sell the tax execution. It also provides for a due diligence when the notices are sent out as far as tax bills or for the potential sale and transfer of the tax execution. If the mail is not delivered, the envelope comes back. We're now expecting and instructing the tax commissioner to take certain steps to try and determine why this mail was not delivered to the person who in fact is the named obligor on the tax records. Unfortunately, too many times I think the letter comes back, it goes in a box because it's undelivered, and nothing's being done to actually take a step further as far as what I call the due diligence. So we've defined due diligence as some things that can be done to ascertain the actual location of that person. It says it may include, but it's not limited to these particular steps. So it is giving, I really call it a statutory suggestion of things to take, but do something as a means of trying to locate that person. It also, here's another important step, and this is a real concern that we've had, I say in Fulton County. It allows for the tax commissioner, even though he has made a sale and transfer of this tax execution to a third party, which is a transferee as we call it, the tax commissioner still stands under his elected obligation and duty to be able to receive payment of those taxes. So if there is a transfer of the tax execution to an outside party, the delinquent taxpayer can still come to the tax commissioner's office and make payment. The tax amount is capable of being calculated very easily by what you have as far as all the statutory fees. There's nothing else but statutory fees that would be added to it. So if a tax payer walks in who's delinquent on his tax bill, and that bill's been by execution transferred to a third party, the tax commissioner is capable of making a determination of how much is owed on that bill and would accept no less than that amount. At the same time, the tax commissioner would have the ability to clear the execution off the records. This has been a problem because when you've had delinquent tax bills, a property owner goes to have a closing on his home. It has been a difficult thing to have information obtained about, first of all, to whom payments being made, getting that payment made, getting in fact the release of the tax execution back for recording. So we wanted to, again, as I stated earlier, have the tax commissioner perform what is an elected duty that he had as the tax commissioner for the county. Section 4 creates the new posting requirements for tax sales. After the tax execution has been outstanding for a year, and that is a year from the time, as we talked about, I believe, a year from it's actually being issued or becoming delinquent, there's again this due diligence under Section 4 as to what is to be done by the tax commissioner in providing the appropriate notice. And we also, in order to try and remove what may be potential steps of litigation, we begin outlined the things to be done, but we state at the very end of that section A, the manner and extent of a diligent search remains with the judgment and discretion of the officer conducting the levy and tax sale. We're not going to have tax sales being handled and done by the third-party transferee. If the transferee says, I'm ready now, I can't get my taxes collected, he is going to go to either the sheriff or to the tax commissioner and say, I'm seeking to have it done. There are statutory fees, provided for what is to be paid in the case of the sheriff, ex officio sheriff being the tax commissioner of the county, to proceed with that foreclosure on the tax execution. So the standard amounts are in place. We felt there's been some misuse of the law in the past because of the failure to get appropriate notice to the parties involved. So we wanted to be clear again that there is to be the due diligence in locating that tax payer, as well as there will be a posting on the property under Section B on page 7. You see under 1B, posted notice means a placement of an appropriate notice as required by law at a conspicuous location on the subject property of the delinquent taxpayer. Such notice shall be not less than 8.5 by 11 in size and shall be weatherproofed appropriately. That way, even whoever's on the property, if that's not the appropriate owner, is going to be aware of the fact this property may be subject to a foreclosure on the tax deed. The Section 5 again proceeds with the notice requirements relating to the excess proceeds of the tax sale. There have many times been, as you sell the tax deed, there will be a higher price paid, offered to be paid rather than what is the amount of the outstanding amounts for the taxes. What's to happen to those excess proceeds? They belong to the property owner. And if you read the provisions we have under Section 5, I wanted to touch on part of it. If there are any excess funds after paying the taxes, etc., from the sale made by the tax commissioner or collector or other officer holding the excess funds, the officer selling the property shall give written notice of the excess funds again to the record owner of the property at the time of the tax sale and to the record owner of each security deed affecting the property and to all other parties having any recorded equity, interest, or claim of the property at the time of the tax sale. So what we're saying is only at this time will there be a need for somebody to do a title examination to find out where does that title stand, to see who may be the appropriate parties to receive that excess funds. A notice to be sent by first-class mail within 30 days after the sale, and just contain certain information. At some point, the tax commissioner or sheriff may deem it necessary to interplead the funds in the Superior Court, and that can be done at their decision. Such funds shall be distributed by the Superior Court to the intended parties after they're showing their proof of the right to those funds. And then it goes on to say that after 5 years have elapsed from the tax sale, if the tax commissioner or the officer holding the funds has not been able to locate the appropriate party, the parties have not come in and made a claim of those funds, then those proceeds shall at that stage be turned over to the State Department. What is the name of that department? I lost it. It falls under one except for placing the process paid over the unclaimed funds. And there's what is it called? The unclaimed property. And I thought that was named in here. That's value less tax commission tax holder for funds. It says over to the department. It is in the chapter, okay. Section 6. This is another area we've had some problems. That is getting a quitclaim deed to clear up the title on the property. Again, as a result of people having property sold, we wanted to show there's a need to expedite getting a quitclaim deed signed by the appropriate parties to deliver that over to the delinquent taxpayer to clear up title. So this is some new language as a part of the Section 48.4-44, Sections C and D and E describing how that's to be done. And Section 7 has a section that prohibits the divesting of state, county, or municipal liens against properties. We've had some cities express a concern that when there's been a foreclosure, they were not notified. So the sale of the tax lien will not wipe out other existing outstanding tax liens that may be on the property because of that sale. That, in a very general overview, discusses the provisions of the bill, and I'll be glad to answer specific questions members of the committee may have about the bill. Yes, sir.
I've had trouble finding where the section says that the tax commissioner has the sole discretion.
The section that we're talking about is on page 4. Let's go to that.
Line 4, page 4.
Yeah, line 4, page 4. That's right. Whenever any person other than the person against whom the execution has issued pays an execution at the state, county, special assessing officer whose duty is to enforce execution may, after 45 days delinquency, transfer the execution to the party. So two things we have here: the discretionary right of whether there will be a sale and transfer of the tax execution rests with the tax official, and it is not something that can be required of him. He has the sole elective right to make that decision, he or she does, under the provision B1. Yes, ma'am, Ms. Oliver.
I'm trying to remember our conversations from last year, because I think we dealt with some of this, and I'm trying to remember that this really related, correct me if I'm wrong, for the Fulton County litigation, and my county didn't sell tax money.
That's correct.
I want to make sure that tax commissioner.
Mr. Scott is here, and he will do that. Mr. Scott, your constituent here asked about, you're not selling tax executions, or have not in the past, correct?
We did sell them for a few years, and when we found out that what we thought were abuses to our taxpayers, we quit selling them.
All right. Mr. Lindsay?
Mr. Chairman, when you have someone like Mr. Scott, who comes up with an alternative method to selling, and he's got probably what, a 98-99% collection rate at least. Better. Thank you. Well, that's my point. I was giving you good credit, now I'll even give you better. I never want to make someone like him sell, because he's obviously come up with an alternative. What concerns me is if we ever got a tax commissioner who didn't come up with other alternatives to collect, and was down, quite frankly, back where Fulton County used to be, down around 80%. Do we have anything in here to give that tax commissioner some kind of incentive to either come up with a better collection method in-house, or have to sell them to a third party? That's my concern. And in all candor, Fulton County being what it is, I know folks are tired of listening about Fulton County, but Fulton County being what it is, and my district being where it is, when the collection rate goes down, they come to my area to collect the difference. And so I would like to see some kind of provision in there.
Well, what you'd have is, I think the way you can do it is you'd have to put a mandate that if it's requested by a third party to buy, they shall sell them, and that's been also one of the shortcomings I think we've had in Fulton County, is some people have not been pleased about finding out their tax bills have been paid to third parties.
Well, like I said, I'm at a quandary here, and I'll see if I can come up with something. Maybe I can, but where I don't want someone like Commissioner Scott to feel it ever have himself, because he's already come up with his own method.
Yeah.
But for those counties that aren't doing their job,
Of course, the incentive is the fact that they've got to collect taxes, If they're not doing it in-house, they better find another alternative. This is the alternative as far as selling it to third parties.
Maybe.
Yes, sir. Any other questions on the committee? We're going to allow a brief opportunity to, and I do want to try, because of the late hour, keep it to, if you have a specific point. I know we got several people here representing either individually tax commissioner's office or representing the Association of Tax Commissioners. And we'll start with that as far as those of you who are representing the Association of Tax Commissioners. If you wish to present some questions or thoughts about the proposed House Bill 931, come forward. Mr. Winger.
Yes, sir. Mr. Chairman.
Glad to have you with
And
us.
committee members, appreciate the opportunity to express our concerns.
All right.
And I can tell you we've worked with you in the past, starting last August, to try to put together a piece of legislation that would be suitable for the 2 counties that wish to sell tax liens, and of course there's 157 that don't. And I think we've got something that pretty much fills the bill, with the exception of, obviously, I think Fulton and Gwinnett counties may have some bones to pick with some of the details. But there are a couple of things that I'd like to express on behalf of the association.
All right, sir.
The Section 2 that deals with the upfront application of a 4% penalty really doesn't have the blessing of our association. And let me clear something up that you may not be aware of. There is, in fact, a 1% penalty, a 1% interest, it's called interest, applicable on the first day after the tax bill is due. So if it's due on the 15th of December, on December 16th, they owe the face amount of the tax bill plus 1%.
That's contrary to what I've been told.
Well, I know, and I understood that from talking to Chad. He didn't understand that, but that is a fact, and he looked it up. 48.240, I think, covers that. And of course, on the 16th day of the next month, there's 2% due, and of course, on the third month, there's 3% plus that 10% penalty.
Yes.
Now, some counties, by local legislation, apply a penalty at the initial due date, or the first day after the initial date. And I know DeKalb, I believe, told me they do a 5% penalty immediately.
That's by local legislation.
Local legislation. Rockdale County does a 4% penalty immediately, and I believe Fulton may have one. My point there is there's 157 counties that really don't care for this piece of Section 2. And local legislation is a great vehicle to address that if that's what they want to do. Would like to see that, and
Good point.
Would like to clarify. I like Chad's wording, but I'd like it spelled out a little clearer, that we cannot be forced to sell tax liens against our will.
I think we've got, and
Well,
you look at the language guy here, it says no officer, look on page 4, no, it says line 7, no officers whose duty is to enforce the tax execution shall be required
Well, I
to
don't
make
have that copy.
Mr. Wendell. Any transfer, which one are you reading from?
Well, 5426.
There we go.
Okay, there is different language, that may be what you're, because I've got it, if you look on this bill, line 7,
Yeah, I see it.
we tried to clear that up without any issue.
that'll do it.
We said it's may, and we also said now you can't be forced to do it without
That's good enough.
your election to do it.
Thank you, sir.
Okay. So the main thing you have concern about would be the question of 10%, and what you're telling me, there is in fact a statutory 1% penalty added immediately upon the next day after the due date. So whatever that due date is from county to county, 1% gets added afterwards.
In every county. It's general state law.
All right. Good point. Other questions you had, thoughts about it, Mr. Wingo?
I don't have any other. There may be other tax commissioners that have issues.
Good. Let me see what the rest of them have to say. Anybody else? As far as tax commissioners, Dr. Ferdinand. Yes, sir. Come forward, please.
Thank you, Representative Leonard. Before I start, let me show you a page I pulled from the Constitution. I've had it for years. It's yellow. These were happier times, where the laws were simple. And I could go after those who didn't pay taxes. I made copies of those as a matter of that page, as a matter of fact. and it shows you what Fulton County was like several years ago.
What's the date of that article?
This is April 15th, 1997.
All right, sir.
That was my first press conference. And it shows there, if you look just at the front part, what the kind of delinquencies were at that time. And the big delinquencies were mainly from businesses, both real estate and personal. And taxes owed for several years. And there seemed to be no way of forcing payment at that time. Well, that changed. Oh, I'm sorry. You want to sit?
Turn.
Sure it was on.
Okay.
It is on, yes.
Okay.
Have a seat. And I know historically what the situation's been. I'm not trying to short circuit your conversation about it. You've desired to have the ability to sell and transfer tax executions. I'm acknowledging that is a desire for your county, for you, in your position as tax commissioner, and I'm trying to address that with the language we have here, which says makes it permissible for you to do it, not mandated, but permissible.
I recognize that, and I appreciate it.
And the purpose is we just want to set up some standards there that we're talking about how it's going to happen, because as you know, nothing in the law now, and in fact the courts have recognized you may not even have that ability.
That's correct.
And if you've got some issues about what we're, and I don't know if you've seen the bill yourself that we've last had
This
changed.
is what I have.
What is the number at the top, what they call the LC number, if you will, on the top of yours, on the right-hand side, the very top of the bill?
I don't have any LC numbers in it.
It does not. Okay, you may want to look at that bill. That is the one we're using, and there have been some changes made as of today.
Oh, okay.
Nothing more than doing things like we talked about, clarifying this issue about the option a tax commissioner has to make the sale.
Thank you.
We've also recognized that this initial, I know from things you and I have had conversations about, the initial issue about due diligence, we tried to limit that to an ability to take appropriate steps to try and find the person.
That's correct.
And that is,
I recognize that.
Looking at what may be readily available records, not having to go out and find somebody on the property, but just your available records. And then when there's a foreclosure, we have a little higher standard of due diligence.
That's correct.
Required.
I recognize all that.
Okay.
And I really appreciate your hard work on this. And this bill has come a very, very long way to being very satisfactory. But I still have a few concerns.
All right.
And let me mention them to you. Well, it may have changed. Just before Section 3, Section 2, numbers 2, 3, and A, the question of what to do with interest and penalties was struck out. And there needs to be...
That was changed. That was put back.
That's put back in?
That's
okay.
all right.
All right, okay.
I don't know where that came from as far as that striking out.
I just want
not
completion.
something we asked for.
Okay, I just want to make sure those things are there.
What's your feeling about the penalty amounts that you heard just testified regarding, do you assess a 1% penalty?
1% interest every month.
Every month, and then you have the 10% after 90 days.
That's right. And that is quite satisfactory to me.
All right.
That is quite satisfactory as it is today. 1% per month and then 10% after 90 days.
All right, sir.
I don't think you want to make it too punitive for somebody who probably don't have the ability to pay immediately, and then first they drop something on them, which make it even more difficult. Okay.
All right.
Let me skip back to the last... the section that talks about the tax commissioners receiving payment from the property owner after liens were transferred. That is a very, very difficult one for me to implement with even the tax system we have, and also by law. We sell an average of about $35 million a year. And if the taxpayers had their druthers, rather than going to the transferee, I think they'll all come and drop it on my lap. Now, you may say that's good. But at the same time, there is this reference here to remove the liens. The liens aren't mine anymore. The liens have been transferred. The original 5 years are now with the transferee. And I don't think the clerk would appreciate my coming across there to cancel a lien that's not really mine. And what this bill does, this particular section, it puts me in the middle of the taxpayer and the lien holder. And I could see nothing coming out of this but lawsuits.
Are you talking about being the one who, if they come to you, Dr. Ferdinand, and say,
Yes,
I
the
want
money.
to pay off my delinquent tax, it's been execution issued, and you take the money, which this says you do, and now you issue a clearing out of the lien as far as what may be on record.
That's correct.
Okay.
That's correct.
Let me tell you the thinking behind this. We can statutorily have what we call someone designated as an agent of a principal. And we're doing that in this case by the fact that you've elected to make a sale and transfer to a third party. We're by statute saying you can do that, but you're going to continue to be in effect the agent of that person to whom you make the transfer for those limited purposes. One is that you will continue to be able to receive the payment, and likewise you will have the right, once you receive the payment, cash payment, to clear off the tax limit. Now, I would suggest what would be done is something is set up between you and to whomever you make your transfers, whether it be a corporation or individual. I know you sell them usually in large blocks. And so to whoever you sell that, you say, okay, the law says I've got to be able to continue to get payment for these executions I'm transferring to you. And likewise, even though we've issued a fair facius on this, I've also got the mandated obligation, if I receive the payment, to be able to clear it off the record. Now, all I need to have from you is be sure I've got a good address. If somebody comes in here, that I'm going to be able to send the money to you, and I'm going to take the steps that the law directs me to do, because I'm continuing the form of your agent by this statute.
Okay.
It's not a happy thing, but I'm saying this is the counter side to your right and ability to sell and transfer those. The taxpayer has elected tax commissioners as an office holder to do statutory obligations. One is to receive payments.
Okay. The beautiful thing, and you probably won't think it beautiful, about a lien transfer is that I get the money immediately, and it's very cost effective. And this idea of receiving money after the transfer makes me handle money twice in a system that's geared up to handle money once. And even though I'm the agent, I could see nothing but a set of lawsuits that come between transferees who are not always the big block transferees, could be very small guys, one person, etc., and myself. And just the fact of handling money twice makes it a very inefficient process for me. That would probably require additional resources, which I certainly am not going to get, and on a system that's built to receive money only once. So it's going to be a very, very difficult thing for me to implement. But I understand your sentiment. But at the same time, I must tell you, operationally, it's not going to be an easy one to do, and could be costly too. Okay?
I would hope to be able to, through your computer, having which tracks all the tax bills, have some means of earmarking the sale of these being to somebody, or even on the books themselves. I know you enter a fact there's been a sell and transfer to somebody. So when you have that, and somebody comes to the payment, you look at the book, I'm sure, and I mean your staff does, and they see that. So I just suggest there's something that needs to be some oversight, just to be sure it's handled properly in that regard. But that is a trade-off that I'm talking about.
I understand the trade-off. I'm just telling you, it's going to be a very difficult one to implement. And but I look at it, but I'm not promising that this is going to be a happy medium.
Yes.
Okay. Let me go to the last page. I want to jump across to this before I forget it.
All right.
And this is that section 7 that was added.
Section 7.
Section 7, the last thing in this document. And this is the ability of having the liens of government survive quiet title. Okay?
Yes.
That's what it says there. Let me make it a little more personal. Let's say you, Representative Willard, buys a lot in Atlanta, and you're going to put your mother's home there. And on this lot, you got it through a foreclosure. And on this lot, there was some ramshackle building before, and the city wiped it out, demolition lien, $40,000. And now you are doing quiet title. If this lien, and let me say that governments are notorious of not showing up after they have been served. It happens in Fulton County and the city of Atlanta and the school board all the time. They'll be served, don't show up. I don't think they should have, to use the judge's word, a second bite at the apple. You now have quiet title. The city, the county didn't show up. There's a demolition lien on it or some other lien. And you build your mother's home on this. And 5 years down the line, here comes the city deciding to enforce that lien that survived that quiet title. I think it's very unfair on you or anybody else to get quiet title or to have title of property which is not clean. I don't think the law allows or permits the transfer of property that's encumbered by other liens. And this is a clear case of it. Cities should be held to the same standard. Cities and counties and all governments should be held to the same standard that a private citizen is held to when served a legal notice. If they don't show up, that's their luck. I think the lien should be cleared off and you should get quiet title so that you should be comfortable that when you build your mother's house there, that somebody isn't going to come after it in a few years' time because something survived. The purpose of quiet title is to make sure that insurable title is passed to the property owner. Okay? So I have a...
Is your notice you're talking about a quiet title? You're filing an action to...
That's right.
To do a quiet title?
Mm-hmm.
Well, that would be the case. I'm talking about here is the language here dealing with the foreclosure of a tax lien. Foreclosure of a tax lien, which that means they may not have received a notice because they're not someone who is a title record holder, but if they say the city of Atlanta may have an outstanding tax bill on that property just like the county did.
Mm-hmm.
And the county goes through a foreclosure of its tax lien, it is not including what may be other jurisdictions having a tax lien other than the school board because you have that part of your tax bill.
Let me address it for you.
Okay.
If the city demolishes a property, they put on the records a lien on that property. And so when we do a foreclosure, we see those liens. We send notice to them. They have interest in that property. They have a lien interest in that property. So they are served. They just don't show up sometimes. They are served.
I'm not talking about lien. Go back to what I'm talking about. A county or municipality for its lien for taxes. Now, what you're talking about is a nuisance situation where there may be an action taken by the city government to clean up a property as a result of a nuisance.
That's right.
And they've expended funds, and therefore there is a different statutory lien filed for that type of situation. Now, if they get a notice of quiet title and maybe they don't come in and respond to it, then they may be charged that. But I'm talking about strictly on the issue of taxes itself.
When we foreclose, in order to get rid of the excess funds, for example, everyone is served a notice who has some kind of lien interest. So they get served. So they could come and make claims against the excess funds. Are we talking about the same thing here?
Somewhat, but suppose the sales occurs is based upon strictly the county tax lien, and that's all this bid. It's lien and it's expenses.
Yes, yes.
Now you're going to also be wiping out the city's potential tax bill that it was not aware that it was going through a foreclosure of the county tax bill, which has wiped out its lien under its taxes.
When I foreclose in a county, all the taxes are bundled in that lien, in that sale.
That isn't true with everybody, Dr. Ferdinand. I'm telling you, it's just not true with everybody. And all we're saying here is if there's a sale, and in your case you may have included it, but if there's not a sale that includes that, then we're saying, do we want to wipe out the other local government's tax lien on that property because there's been a foreclosure of the sale of your tax lien?
I would say yes.
Well, let's decide that as a policy then on this
Give
point.
them notice.
Let's decide
and they
that
could
on
come
policy.
forward to
Okay.
claim against the excess funds.
All right.
And if they don't show up, then I think it should be wiped out. I think you should be entitled to get clean title so that nobody should come against you in the future.
Mr. Chairman, can I ask
Yes.
Commissioner, if you're already doing this, basically, if I understand what you're telling me, is that when you go do a tax sale, you bundle all the liens.
The taxes.
Yeah, you bundle everything to, and so you're
taxes.
already taking care of all these.
That's correct.
And yours. So, and I think that sounds like a good policy. So what's the problem? I mean, well, all we're doing here is trying to make sure that other folks who do the same thing in terms of tax sales do it the way you do it.
158 other counties.
We're trying to make sure that everybody else is doing it the same way you're doing it, basically. I'm not sure if I'm following what the problem is.
Well, that would be a good thing to get others to do the same thing. But
Yes.
I was looking at it from my standpoint. And I was looking also at any other liens that were existing. And I think that a judicial sale or any of these quiet titles should clean the title completely. And nothing should survive a quiet title, as far as I'm concerned.
That's a quiet title. That's a different proceeding, not a tax foreclosure sale.
A tax foreclosure usually ends up with a quiet title.
That's debatable, but I'm not going. I mean, that's a question about title standards, which we're not trying to address in this bill. But title standards is what you're talking about.
Okay.
Okay. Anything else on your
I'm not finished
presentation?
yet.
Any questions of Dr. Ferdinand? Does anyone else wish to briefly address the issue of House Bill 931?
I have one more item I'd like to address.
Okay.
And that is the last section of section 3, just before section 4.
All right.
And this notion of having a transferee not being able to participate on the quarter steps in a foreclosure.
The transfer of the tax authority into common ownership. Okay, what we're doing there is, go ahead, I'm sorry.
From my standpoint, that sounds somewhat like a restraint of trade. Take, for example, the Braves. The Braves has a product they put on the field.
Yes.
Something saying that the Braves cannot have air the games of the Braves, restricting them from participating in that is similar to what this means to me. I would say that if a company has transfers liens and then has a separate corporation who wants to purchase on the quarter steps, I think that should be fair game.
Well, let me tell you the problems, may have happened in many cases that I've heard about and seen litigation over, and that is the fact that the person to whom this tax transfer has been made goes to the foreclosure sale, and at the foreclosure sale there may be $1,000, we'll say, owed taxes, and they'll bid, of course, $25,000, let's say, is an amount, and the property is truly market value wise maybe $80,000. But the person who has to now pay off the tax bill, which they couldn't pay off, has now got to pay off potentially the $25,000 amount, and they have no way of raising that money to get it paid off because the money is paid in the court, and they've got to try to go and improve their right of that ownership of the money. And we're trying to cut out what we felt were some particularly unpleasant situations where the holder of that transfer has a means of going through the foreclosure and then ultimately the 1-year statute because the people who had that tax bill owed were not able to raise the money to pay them off with all the interest that keeps accruing on that amount. So we only locate as to the person who's a transferee as far as this limitation. The marketplace is still open to others to come in and bid on it.
But a corporation in which the transferee is a principal is excluded. Right. I don't think that's going to ease the problem of somebody bidding it up high and making it difficult for the property owner to get that, to be able to pay it. It still happens.
And that'd be a policy issue.
Well, I think there needs to be some more things in that to prevent somebody from making it very, very high and excessive for the taxpayers.
Thank you. Any questions regarding that?
Yeah, actually, I'm trying to follow what you're getting at here. let's just say there's $1,000 owed on the taxes, and
It goes to
the owner,
foreclosure sale.
it goes to foreclosure sale. The owner of the tax lien pays property's worth $80,000. Mortgage on it is $20,000. The tax person who owns the tax lien bids $25,000. The money goes into the registry of the court. The mortgage holder would be the first one to be able to come and take the money after the person who owns the tax lien gets their $1,000 back. I'm asking here.
There's going to be, I think there's going to be a hearing.
Yeah.
There's going to be a hearing, first of all, to determine who has a right to make claim to those funds.
Mm-hmm.
Now, the person who owned that property, as a way of trying to clear up their tax deed that's been issued now as a result of the foreclosure, which they have 1 year to do,
Yes, sir.
has got to come up with the full amount of money. And there may still be no way for that person to get a hold of that money in court as a means of saying, here's part of the money. So they've got to come up with the full $25,000, we'll say. And they couldn't come up with $1,000 payment. Now they've got to come up with more as a result of the tax deed sale as a way of doing it. Now the mortgage holder may or may not have been notified. Perhaps they were. And they may come in and make a claim to it. But that's still not going to remove the right of redemption as far as the $25,000 that has to be paid to the holder of that tax deed that they bought at foreclosure. And there's been a debt cleared off, they still got $25,000 they have to come up with as a means of doing it.
But the $24,000 of it,
as a debt was removed. And they may be able to pay off their debt monthly as they were doing on their mortgage. It's been a use. I felt there's been some things I read case-wise where there's been a misuse by bidding highly over the amount of the tax bill that limited the person who owed that bill from being able to get the funds necessary to pay it off.
Okay.
That's all.
I'm still.
Dr. Ferdinand, does that cover it?
I'll stop for now.
Okay. I want to go to do we have anyone else who would like to speak? Mr. Mueller, I'm going to have, if you can just, because of time standpoint, I'm going to go through them,
Thank you, Mr. Chairman. I'll be real brief. My name is Clint Mueller with the County Commissioners. This is something that the association has looked at for several years now, and we appreciate you bringing the legislation, and we especially appreciate the part about the local decision-making on whether these things are sold. We had a real concern at one time when we felt like we were being forced to sell these tax executions. The only position that's, I guess, different in our policy platform from the way your bill is currently crafted is that our commissioners would like to be involved in that decision-making process of whether these things are sold. Obviously, in most cases, I don't imagine there'd be any disagreement between the tax commissioner and the county commissioner on whether these things are sold. In fact, it's the county commissioners that have to support their budgets, and any delinquent taxes, any loss in revenue, such as in Fulton County where we had a 10% delinquency rate, obviously affects their ability to manage their budget. So they would have an interest, I'm sure, in making sure that those taxes were collected. But the position from the county commissioners is they would like some sort of a joint decision making on whether the things are sold or not. Thanks.
Thank you. Yes, sir.
Mr. Chairman, Ron Jason of Georgia Real Estate Investor Association, ladies and gentlemen of the committee. To be very brief, there are two technical matters of language in the bill. These were determined by the committee in its August meeting and were taken care of in other parts of the bill. It's just a couple of pages where it just didn't come through in this final version. Page 5.
Be sure you're working on 5437S.
I made sure I was, yes.
Good, okay. Page 5.
Yes, sir. If you'll notice, and this is all, of course, different subsections in the same code section, line 8, it's a requirement of the transferee to provide under certain circumstances a name, mailing address, and telephone number for the transferee.
Right.
And we wanted to continue the consistency of the mailing address requirement down on line 35. And so would ask that the committee, between the words including and address, just insert the word mailing. And of course, I'd be happy to discuss the substantive matters, but I don't know that you all want to do that, but I'm here for that. On the second one on page 7, and I'm in a hand, if I may, I'll just slide them over. Mr. Chair. This deals with the paragraph 2, starting on page 7, lines 9 through 14. So there's 2 sentences to the paragraph. The first one's in the active, then it sort of switches over to the passive, and that creates a confusion. And as you can see, and I gave you my last copy, but the idea would be to include on a couple of places there on line 12, the first insertion, to make it clear that it would be the officer or any of those persons providing the written notice, the key being not the transferee, and then the language just follows along, just grammatically, what should be stricken.
In addition to the notice otherwise required under this code section, and list at least 10 days before the tax sale, you're suggesting write in the transferor, sheriff, tax commission, tax collector, or officer selling the property shall provide written notice.
Yes, this was the language adopted by the committee for the other portions of the posting that have since been eliminated from the bill. And then the rest just follows in grammatically.
Well, for one thing, the transferor would be. Now, we, of course, talk about the officer conducting the sale as the beginning of the sentence.
Yes, let me mention, I lifted that language because I wasn't sure at the pleasure of the committee. It probably could just say the officer or said officer at this stage in the process, at the sale process. I just wanted to provide the original language, and my concern is that it's not the transferee doing the posting on the property. I don't care which committee adopts.
I'm sorry, go back.
I was just saying that the concern is just that it's not the transferee, and this the way it's stated here, it's ambiguous. I don't care which of those options are chosen, just that it make it clear that it's one or more of them, and not the transferee. Because the way with the switch to the passive, it's just not clear who's involved to do the posting at the property.
Thank you. Excuse me.
Mr. Chair, I was just saying that it's not. I lifted up the original language that was in the other portions, but I don't care which is kept by the committee with this consideration, just so long as it's clear that it's someone other than the transferee. And one or more of those may apply, and simply the officer being repeated may apply.
All right.
I'm available for
Anything
questions.
else you have?
No, sir.
Thank you so much, Mr. Jason.
Thank you, sir.
Anyone else? Yes, ma'am, Ms. Hutchins.
Thank you, Mr. Chairman and members of the committee. Mr. Mueller has essentially outlined Fulton County's philosophy, but there is one thing I'd like to deal with. Dr. Ferdinand made a comment about it taking resources, and those are things that he certainly would not get. In 2002, after the General Assembly passed the original bill, the county looked at what Dr. Ferdinand might need, and while he may not have gotten absolutely positively every dime for which that he may have requested, twice within that year, in June and in August, he was given money, over $1 million, to provide positions, and it's my understanding that there were a little better than 20 positions that he got as a result of that. They were not necessarily used for this purpose. They may have been transferred for other purposes, but the county did give, the Board of Commissioners did give the resources they felt were necessary to do the job. So if asked, the resources are very likely to be given. Thank you, Mr. Chairman.
Thank you, Ms. Hutchins. Anyone else wish to speak? Yes, sir.
Mr. Chairman, committee members, I'm Jim Meeks with Morgan Financial Corporation, and we're a specialty finance company who acquires commercial loans and municipal tax liens. And just to give you a quick sense of my expertise, I'll try to keep this very, very quick. We are one of the 3 largest municipal lien purchasers in the country. At our peak, we were at about $250 million under management at one point in time. We manage and acquire in 22 states in the country, and our bank funding comes from Bank of America, Wachovia, 5 other, pretty sizable national banks. Our company was established in 1982, and I've served as its president since 1999. And in my opinion, transfer of executions is a very beneficial tool for the officials who want to use it, of course. Many counties across the country who experience a low collection rate, kind of in the 80 to 90 to 95% range, use this tool to get their collection rate up to 99. Like you discussed earlier, there is a level that probably makes a lot of sense that you do this process. In addition, the secondary benefit, it's a way of relieving the administrative burden of having a large amount of delinquencies held by a municipality. Counties will have this ability to relieve themselves of these burdens if they wish. When looking at legislation such as this, the main factors that we look at would be that there's effective and sufficient noticing to protect the due process of the taxpayer, a well-defined system to secure the priority of a lien, what it wipes out and what it doesn't wipe out. It's nice to have a requirement for an open process of awarding the transfers when there's competition. We think overall it just needs to be a common sense and efficient process for the tax officials who want to use it. And we like to see built-in incentives for the transferees, which would be us, to notice properly and basically follow the rules. I've spent a lot of time reviewing this legislation, proposed some language to the author of the bill, and I think this committee substitute for HB 931 is a very effective and complete piece of legislation. I do, however, share the concern that Dr. Ferdinand brought up about the post-transfer payment directly to the tax official. I think that does take away a little bit of that benefit of taking the burden away from the tax commissioner's office, the administrative burden, and it does create a little bit of conflict. I mean, you can think about right after a transfer, there's going to be a 60-day notice that the transferee does. What happens in that meantime? It sure would be a lot easier for us to do our job and do it efficiently and have the county direct the taxpayer to our 800 number, our office, or whatever it may be.
Mr. Bishop, I'm sure you do a good job with that.
Yes, sir. We
haven't always had that in the situation as far as abilities in Fulton County in the past. And I felt the only way we could address that is what we're trying to do with this arrangement called about a statutory principal-agent relationship. You sell it, you as a tax official are still going to have the right to take the payment if the taxpayer comes in and says, I want to pay off my tax.
Well, if they have the right to do it is different than requiring them to do it.
We don't require it.
Okay.
Just give them the option. They can deal with you or they can deal with the tax commissioner as far as paying it off.
It would, the one, I agree with that, but the one position I think would be helpful would be if someone came in and said, I can't get hold of that transferee, then it's accepted.
How you determine that standard?
Yeah, well, that's a good question. It could be as simple as we have a phone number, the tax collector calls it immediately, and we either answer or we don't.
He does know that.
Okay.
We thought at one time requiring the transferee to have an office for sure in the county. You want us to do that?
Yeah, if our company, we have a main office. Yeah, I understand, and I think that if there's a large enough investment in the county, it makes sense.
You're buying a few of them or buying a million of them. Then you have the standard saying, well, what size do you then say has to have an office? And I think the appropriate thing, the standard we're saying here is you got an option, you got a right to sell it. If you do sell it, you were elected for a purpose, and that purpose is to receive the payment. And just continue that. And just use the transferee, work it out with the tax commissioner.
Right.
Here's how you reach me. You got a payment in, contact me.
Fair enough.
Anything else? And we put some standards in here, dealing with the things the tax commissioner should do in notifying persons who may desire to buy transfers.
Right.
So it's should be an open process.
Good. Yeah, and I agree with that. I think overall it's a fabulous bill.
Well, from a time standpoint, I'm going to close off any further debate, and we'll go to the committee for discussion on the bill.
Okay, thank you, Chairman.
Thank you. Do we have discussion among the committee members? Do we have a motion?
Wait a minute, Mr.
Let's do a motion on the bill first.
Okay.
We have a motion. Do pass. All right. Any discussions on the motion do pass or amendments to the bill?
I'm still, Mr. Chairman, trying to figure out, and maybe I'm just slow, but I'm trying to figure out Section K in Section 3, page 6,
yes.
Subsection K. The logic behind limiting the ability of the owner of the tax lien, their ability to buy back the property in the tax sale.
They can buy it back. Just the price we said there was they could not do it for more than about the transferee.
Yes, sir.
The bidding amount they would be limited to would be the amount of what they need to do as far as recovery of their investment.
Well, let me ask you. Let me ask this. Right. This may help me out here. If going back to my situation, if they did bid $25,000, that $25,000 goes into the registry of the court. $1,000 gets spent to pay off the lien. Where does the other $24,000 go?
If there's a lien holder, as far as a security deed holder, they can come in and make claim to their portion that's retained in there. The balance of it, if any, would be something the property owner would have a potential right to receive if there aren't any other lien holders above that.
So by this rule, my question then is, by this rule, are we hurting the mortgage holder?
The mortgage holder has got the right also to come in and redeem that deed of secured. The tax deed, and they have to receive a notice of it. That's the question. Yes, sir.
I talked to Mr. Lindsay ahead of time. That K bothered me because I thought it would shield the bidding process. Yeah. Most things I've seen as lawyers where somebody will buy it in at $360,000, $350,000, looking at deed secured debt in the property records, and it's only $20,000 owed really at the bank if they'd got a payoff. And then a homeowner would have to pay over $70,000 to buy out, the first 20%. And it does bother me about chilling the bid process, but I think the pain is, I think this addresses, these aren't burdens, these are people. And I think that's who, I heard referred to as burdens. These are people. And I think we have a duty to protect them. And that's why I've gone all the way on K.
Okay, I think I understand. Thank you.
Any motions?
Mr. Chairman,
yes, ma'am, Ms. Oliver.
I'm not familiar enough with the bill or the work that's gone into it, but Mr. Jason was suggesting an amendment on page 7, line 12, to be consistent with other parts of the bill.
That was his written amendment, number on House Bill 931. And I don't have any real problem with it.
Can I offer this amendment as it's drafted and is distributed to the committee?
That's fine. We're talking about amending on page 7, starting at line 9, and inserting the language on the written page as in place of what is lines 9 through 14. Does everyone understand that?
Yes, sir. That's what I'm amending.
Any objection to the amendment? The amendment's added. One other amendment. Yes, sir, Mr. Tumlin.
Just to get on the table, I'd like to move that we strike Section 2 in its entirety.
Section 2?
Yes, sir.
All right. Section 2 is the area that dealt with the change on the rates of interest. Motion's been made to strike out Section 2 in its entirety. Is there any objection to the motion? Any objection? You object. There's a Objection to the motion. We'll have a vote on the motion. Any discussion on the motion?
Tell me what it does. Tell me
Okay, what we did here, and this is also for those who may not have been here during the discussion, we were looking at a way of setting up a two-step on this 10% penalty, not realizing what was brought to our attention, that there is, in fact, a 1% penalty that becomes automatically added at the time of the past due amount.
So I understand Mr. Tumblin's amendment to be to eliminate the duplication.
Is to go back to what the law is. This would remove any change in the current law. The current law is.
Well, where's the 10%? 10% then goes away.
The 10% will be added after 90 days.
And is that current law?
That's current law.
So, Mr. Chairman, he
Yes,
said
ma'am.
strike, I didn't know he says to revert back to current, but strike, or section 2, strike that code.
Because it says insert in lieu of.
Yeah, amendment to it.
You didn't say.
I'm sorry if I misstated that. This is actually just taking out the amendment to section 48.244. So we're taking out it being in any amendment. Section 2 would be amending that section, so we're not going to have an amendment if his motion to amend passes.
Revert back to current.
Yes, ma'am. Any further discussion on the motion? All in favor of the motion signify by saying aye.
Aye.
Opposed, like sign. The motion carries. So the changes we're contemplating in section 2 has been taken out. Any other amendments from the committee? Yes, sir.
I put it out for discussion purposes. Page 4, get back to my concern regarding what happens when the county isn't collecting as they should. I would insert at page 4, line 9, at the end of that sentence, the words, unless the collection rate for the county for the preceding tax year falls below 95%.
Then what happens?
Line 9, page 4. So basically the sentence would read, no officer whose duty is to enforce an execution issued for state, county, or municipal taxes or special assessments shall be required to make any transfer or transfers of such execution or executions unless the collection rate for the county for the preceding tax year falls below 95%.
Well, as of what date? I mean, that's the question I got. When do you come to the triggering? I think we got a problem trying to trigger in something. We don't have enough.
Well, I tried to trigger in the preceding tax year, Mr. Chairman.
I know, but that'll be on January the 2nd.
Yeah.
Because your taxes come due in most cases like December 20th.
What I'm looking for, Mr. Chairman, and if I may ask for a little bit of help here, is if the county has a history of problems in terms of it.
Let me suggest this. I'm not trying to shorten you.
Yes, sir.
Why don't we work on what you're trying to accomplish as opposed to doing it here, and perhaps get an amendment on the floor.
I'll work with you, Mr. Chairman. I'm happy to do that. That's my concern. DeKalb County's doing it right. Quite frankly, Fulton County right now is doing it right. I mean, they've come up with two totally different ways of doing it, but they're both collecting that up close to 100%.
To their system.
I just want to make sure that if any county, for whatever reason, stop doing it right, that somebody's going to have to sell these things to a third party. But I don't want to compel a sell if the counties are doing it right.
All right. A good point. Any other amendments from the committee?
One.
Yes, ma'am.
The additional mailing address.
Right. That's a good point.
Did you do that?
We're going to talk about a line 35 of page 5 after including insert the word mailing. Any objections to that amendment? Amendment stands. Any other amendments? You ready to call the question? Question called. All in favor of House Bill 931 as a committee substitute as amended, signify by saying aye.
Aye.
Opposed, like sign. The ayes have it. Thanks to everyone. And I'll work with you on that later.
Yeah, what I'm doing there off